this is the first time you're going to experience something like this. You have not, this is the first time that you're going to have a paper like this. Previously, you had CL4, one whole paper to cover this subject, corporate law. But now it's a combination of both corporate law and taxation. And therefore, it's extremely important that you prepare yourself for this paper, not only with the subject knowledge, but at the same time about the format of the paper, because 55% of the paper coming from corporate law, balance 45% coming from taxation. And then you need to make sure that you allocate your time accordingly to face all the questions, not only from corporate law, but also from the area of taxation. And for that, what you should do is, I will give you some, like, tips for you to take away. That is, you must be familiar with the format. For that, what you should do is read these instructions carefully now itself. Understand what you're supposed to do at the exam. And since you're going to face something like this for the first time, it's quite normal that you get nervous, that you can get excited. So because of that, if you know what you're going to face at the exam, now itself, if you prepare yourself, then it will not be very uncomfortable to face the paper, and you will be comfortable at the examination environment. Therefore, familiarize yourself with the format of the paper. So straight away, we will read what the instructions that we have been given. So time allocated here for this paper is 15 minutes reading and planning, and then writing 3 hours. So here you have 180 minutes. Apart from that, you have another 15 minutes. This is to answer both corporate law and taxation. So the total marks are 100. So basically, to score 1 mark, you are permitted to spend 1.8 minutes. This paper consists of 2 parts. Part 1, corporate entities, formation, governance, and legal frameworks, 55 marks. And that is the area that I'm going to cover during the next 1 hour, 1 hour and 45 minutes. After that, the next resource person will cover the taxation area. So section A, 3 short scenario-based questions, all are compulsory. I'm only going to discuss part 1, okay? So there are 3 short scenario-based questions which are compulsory. And then you have section B, 2 extended complex scenario-based questions, answer any one question. So there you have a choice. You have 2 questions out of which you have to answer 1. So altogether from part 1, you have to answer 3 questions and plus 1 extended complex scenario questions. Altogether, you have to answer 4 questions. 55 marks allocated. 55 marks allocated. So that means basically to answer part B, always ignore the reading and planning time 15 minutes. Consider it as a bonus that you have been given. So don't try to rely too much on that. Just assume that you have only 180 minutes. And to answer part 1, you can spend 99 minutes. 99 minutes. Okay. So for convenience, always think that you have 1.5 hours to answer part 1. Just 1.5 hours. But you'll be having extra 9 minutes. But again, don't rely on that extra 9 minutes. Assume that you have 1.5 hours to answer part 1, right? So begin each answer in part 1 and part 2 on a separate page in the answer booklet. So don't make mistakes, because administratively it can be difficult, because these are 2 different areas, tax and law. So because of that, marking can be difficult and you might lose a lot of marks by making mistakes. So make sure that you answer part 1 and part 2 on a separate page in the answer booklet. Then the examination will be conducted as an open book examination like CL4, and only the following publications will be permitted to be used at the examination hall. So for part one, for the area that I am going to cover, it will be the Companies Act number 7 of 2007. But remember, there are two amendments to the Companies Act number 7 of 2007. I'm sure that you're familiar with it. There is an amendment that brought in 2019, and then in 2025, last year, and 25 is a material and significant amendment to the Companies Act. Make sure that you have the original Companies Act and all the related amendments that I referred to. Then candidates are allowed to bring or use the above permitted publications subject to the following: highlighting, sidelining, underlining relevant sections in the publications are only allowed. So highlighting, sidelining, underlining relevant sections in the publications are only allowed. Short notes, or so that you can do, it's permissible. But short notes or any other notes written on the permitted publications are not allowed. Because there was a time period when we were doing CL4 that was actually permitted. So I used to advise students to use it, but it's no longer there. So you can only highlight, sideline, underline relevant sections in the publications. That's it. So attaching, pasting, or inserting any other documents to the permitted publications are not allowed. Page tabs to refer the pages are allowed. So you can do page tabbing also. Then notes, textbooks or any other materials will not be allowed. Photocopies, extracts of the above publications will not be allowed. So always get it from the Publication Bureau, the official copies of the Companies Act along with the amendments. All the answers should be in the English language in the answer booklet given you. Answers written on the answer booklets, graph papers, and any other stationery distributed at the examination hall only are considered in making of the answer script. Any other attached documents are not taken into account at the time of making the answer script. You might be thinking, okay, this is not something extraordinary. Yes, true. But since it's the first time, you should know what you're going to experience, what you're going to face, and prepare yourself, because then you will not waste time unnecessarily. Remember, this is going to be challenging, not because of anything else, because you have to answer all the questions as required here within 180 minutes, and then you have to switch your mind from law to tax. Now, if you have to focus only on law, then you can train your mind for that. But here, 55 marks, that is basically 1.5 hours. You're spending time to answer questions from law. Then suddenly you have to switch the brain to another mode, and then balance time period should be used to answer tax questions. So there's a psychological aspect as well. So don't take it for granted. Practice now itself as well. So straight away, we will now start answering the questions that you have been given. Okay, one more time, let me check. So I believe all good and you guys can hear me very well, and that the paper is yeah. So one student has asked question, will you provide recordings? I'm sure the Chartered Institute will take steps to do that. They will share these things, recordings on YouTube channel. I'm not sure, but you guys can ask from the administration of the institute. Okay, right. By the way, I believe that my introduction was clear. So just to give you who am I, I'm Rakita Jayatunga, because that introduction part I gave at the beginning. So I'm a lawyer plus fellow member of the Chartered Institute, fellow member of the Chartered Certified Accountants in the UK, also known as ACCA, then also a member of the Chartered Institute of Sri Lanka. So I have good understanding about different kinds of papers, law and accountancy, and you guys are accounting students, but facing a law paper. So what kind of an approach that you should take when answering questions. So now let's look at the paper, because the focus should be on the paper. Right. Corporate entities, formation, governance, and legal framework. That's the paper. Total marks of part 1 is 55 minutes. Section A, we know. Section A, all questions are compulsory and you get 3 questions allocated 30 marks. Allocated 30 marks. So 1.8 into 30. So basically you can spend 54 minutes. It's already mentioned here. Answer. So always keep those things in mind. Right. Question 1, we'll read it. You are a legal consultant advising Mrs. Dilini Fernando, who currently operates a successful online organic skincare business called Nature Glow. The business has expanded significantly over the last 4 years, now supplies products to supermarkets and pharmacies across Sri Lanka. Okay, right. Then Dilini plans to open a manufacturing facility in Gampaha, obtain a bank loan of rupees 80 million, bring in her brother and cousin as investors, appoint a professional operations manager, and enter into a long-term supply agreement with a foreign distributor. So typical way of expanding a business that had been become little successful. So she has come to a stage. So she had been in the market for the last 4 years and she has been able to establish her business. Now she wants to go to the next level by expanding the business. And for that, she's planning to do these things: opening a manufacturing facility, obtaining a bank loan, and getting her brother and cousin as investors, and then appointing a professional operations manager and enter into a long-term supply agreement with a foreign distributor. At present, the business operates through Dilini's personal bank account. Dilini's personal bank account, right? Dilini's personal bank account. And all contracts are entered into her in her personal name. So these things you must identify at once. This explains the nature of the business. Now, one more thing, since it's a small question for 10 marks, it's okay. You can start with the facts. But usually, my advice to students is, even though I started straight away reading out the facts of the question, it's always advisable to start with the required questions. Before reading the question, straight away look at what you're supposed to do. A, explain two legal characteristics of a company and assess their significance to Nature Glow's proposed expansion plans. Evaluate whether continuing as a sole trader or incorporating a private limited company would be more appropriate at this stage of the business. Support your conclusions with reason linked to the scenario. Then analyze the legal implications and risks relating to the proposed pre-incorporation contracts and advise Dilini on the protection available if the company subsequently adopts these contracts. Right? Now, explain two legal characteristics of a company and assess their significance to Nature Glow's proposed expansion plans. Now, this question, the first part, it uh, requires us to identify or explain, rather, not identify, explain two legal characteristics of a company and assess their significance to Nature Glow's proposed expansion plan. Now, I believe you were able to identify that. Now, there are so many characteristics of a company. There are different business vehicles. You can start your business as a sole proprietorship. That is what Miss Dilini Fernando has done so far. It appears that she's running the business in her own name. Here, everything goes into her personal bank account. All contracts are entered into her personal name. That indicates she's running her business as a sole trader. So that's one way of running a business. Or else you can start it or you can do a business as a partnership. But the best option available is running a business as a company. Now, these are different business vehicles, methods available for a person to commence a business or else at some point to convert the business. Now, sole proprietorship, she's going to convert into a company that is clear when you look at the questions that you have been given here. So have a good understanding about the question, the background, right? So you know when it comes to sole proprietorships and partnerships, as opposed to a company, the legal characteristics are little different. Legal characteristics are little different. One second. Now, one of the most important characteristic of a company as opposed to either sole proprietorship or partnership is what? Is what? Separate legal personality. Separate legal personality. That is one important characteristic of a limited liability company as opposed to a sole proprietorship and partnership. Now, in a sole proprietorship or even in a partnership, they are not considered to be separate legal persons because the law doesn't identify a sole proprietorship business or else a partnership as a legal person. There are two types of persons in the eyes of law. One is natural persons, the other one is artificial persons. Natural persons are human beings like us. We are individuals, we are natural persons. Law recognizes us. So if you, as an individual, as a natural person, you can take legal action against other parties. Other people can take legal action against you. You can enter into contracts in your name, like Dilini has done in this instance. That can be done. So that is because a natural person is considered to be a legal person before law. But a sole proprietorship business or partnership business. Now here the name of the business is Nature Glow. Nature Glow. That is not considered as a legal person. Even if you run it as a partnership, the business of partnership will not be considered as a person in law, as a person before law. So that's how it works. So a sole proprietorship or partnership cannot take legal action against other parties using its name. Other parties can't take legal action against the name of the sole proprietorship business or the partnership business. It's not possible. Therefore, in this situation, what happens is, since Dilini has entered into all business contracts in her personal name, she will have to take the personal responsibility for all these contracts. That is what we call liability. Liability. That is what we call liability. Now, there are two types of liability. One is limited liability, the other one is unlimited liability. If you take a sole proprietorship or else a partnership, now for an example, if you take a partnership, if you take a partnership, right? If you take a partnership, there you can have partners. There you can have partners. But remember, each partner is considered to be having unlimited liability. Unlimited liability. One hand, partnership is not a legal person, not a person before law. Therefore, the partners have to take personal responsibility for all the transactions and contracts of the business. So if something goes wrong, these partners have to bear the full liability collectively and individually. Collectively and individually. That is what we call unlimited liability, because if you have a situation where the partnership has obtained, let's assume that now they are going to take a bank loan of 80 million. Let's assume you have taken a loan of 80 million. And if you are a partnership, and if something goes wrong in the business and you struggle to settle the loan, there's no excuse. The partners have to somehow settle this 80 million. If the business doesn't have adequate assets or money to settle this 80 million, still the partners have to pay this 80 million to the bank because they have an unlimited liability. They have an unlimited liability. So that is one disadvantage of running a business as a sole proprietorship or partnership. One hand, you are not considered to be a separate legal person. Separate legal personality principle is not applicable. Then the next characteristic is you have an unlimited liability. But if you start your business as a company, if you start your business as a company, then things will be different. Then the things will be different. How? How it's going to be different? Right. Then what happens is, if you're a company, the owners are known as shareholders. Owners are known as shareholders. Now, compared to what I explained a little while ago, there you were a partnership. But now the only difference is you're a company and you have shareholders instead of partners. Same example. You take 80 million rupee bank loan. Company starts struggling. Company becomes insolvent. They don't have enough assets to settle the liabilities. Then what happens? The shareholders will not be liable to settle the loan because one hand, the company and the shareholders are not the same. If you take a partnership and partnership and the partners are the same. Partnership and partners are the same. Because partnership is not a separate person. But if you take a company and shareholders, company and shareholders are two different parties according to law. Company is a separate person before law, but it's not a natural person. Therefore, we call them artificial persons. According to law, we have two types of persons. One is natural persons, the other one is artificial person. A company considered to be an artificial person according to law. Shareholders are distinct and different from the company. They are independent parties. So here, company is a separate party and these individual shareholders are on their own. They are natural persons here, according to my example. They are shareholders. However, the company has obtained the loan. So if I have obtained the loan, I am liable. If you have obtained the loan, you are liable to the bank to settle it. If the company has obtained the loan in its own name, then it is the company which has the responsibility to pay this loan, not anybody else, not the shareholders of the company, because they are distinct and different from the company. That is what we call separate legal personality. On the other hand, shareholders' liability is limited to what they have invested in the company. These are basic principles in company law, and I'm sure you're familiar with it. But one thing that students don't understand is that there are a lot of other principles that we have developed, or a lot of other principles have evolved from these two basic principles in company law, that is, separate legal personality and limited liability of shareholders. Assume this shareholder has invested 10,000 rupees in the company, B has invested 20,000 and C has invested 30,000. So A's liability to the obligation towards the obligations of the company is limited to 10,000. My liability is limited to what I have invested in the company. B's liability is limited to what he has invested in the company, which is 20,000 according to this example. Then C's liability is limited to 30,000, that is his obligation uh, towards the company. So this is a good thing because as an investor, I know if I invest 20,000 rupees, that will be my liability towards the company. That means if something goes wrong in the company, that is the maximum I am going to lose. I invested 20,000, my liability is limited to 20,000. That means if something goes wrong, the risk that I have to take is 20,000 because I might lose that 20,000. If I have invested 30,000, my liability is limited to 30,000. That means if the company goes bankrupt, I might lose that 30,000, nothing more, nothing less. That is my maximum liability. We call it limited liability. So the answer to the first question is that explain two legal characteristics of a company and assess their significance to Nature's Glow proposed expansion plan. That is what I explained, but I try to be more specific to relate it to Nature's Glow. But the two legal characteristics that I have identified, there are several others, but I want you to understand these two characteristics very well because most of the other principles in company law are uh, rising from these two principles. If you talk about a majority rule, all those things are interlinked, they are connected to this separate legal personality principle and limited liability. So the two characteristics are those. Then we will see how it will have a significance to Nature's Glow proposed expansion plan. I have already explained it, but we'll try to be more specific here. That is, everything so far has happened, has been done in the name of the sole proprietor, Miss Delaney Fernando. So she has to take personal responsibility. So her liability is so far unlimited. Her liability is so far unlimited. If there is a breach of contract, if the company now, if she continues to run as a sole proprietorship and assume that she starts a manufacturing facility in Gampaha, obtain a bank loan for 80 million, appoints a professional operation manager, then brother and cousins as investors. That means basically without converting into a company, then it will become a partnership. Then you enter into agreements with suppliers. You take a huge risk. Why is that? Then Delaney will be having an unlimited liability towards all these obligations. To pay back the bank, to return the money to the bank with interest will be your personal obligation. Paying employee salaries, other things, paying suppliers, everything will be your personal responsibility. But the moment you convert your business into a company, you become a shareholder of the company becomes a separate person. So all these contracts can be done in the name of the company, not in the personal name of Delaney. Then what will happen? Liability will be shifted to the company from Delaney, liability will be shifted to the company. So it's not going to be her personal responsibility. Now, that is important when you want to protect your reputation as well, because none of these contracts will now come under your name. Everything will happen under the name of the company, in the name of the company. So that is definitely favorable and beneficial to the owner of this company. So basically, uh, this manufacturing facility, obtaining a bank loan, bringing investors, brother and cousin will become two other shareholders. Then the supplier, the foreign distributor, will enter into a contract with the company, not with Delaney. professional operation manager will be hired by the company, not by Dilini. So by doing that, she can avoid her personal responsibility towards any of those parties. So the company will own properties, company will enter into contracts. If something goes wrong, the company can sue, the company will be sued. So those are the important aspects of separate legal personality. So, and on the other hand, Dilini's liability will be limited to what she has invested in the company. So, one hand, because of separate legal personality, the company as a legal person can own properties, can have obligations or liabilities, can enter into contracts with other parties, can sue other parties, can be sued by other parties. So, Dilini will be having less responsibility, everything will be shifted to the company. Not only that, Dilini's liability will be limited to what she has invested in the company, nothing more, nothing less. But if you continue like this, your liability will be unlimited. If the business becomes unsuccessful or bankrupt, then Dilini will have to sell her personal assets to settle all the liabilities. So that is the danger. So the answer to this question, I took some time to explain it, but within 5.4 minutes, you have to answer this question. Within 5 minutes, we'll say 5 minutes. Within 5 minutes, answer this question. Not a big deal. So again, separate legal personality that will permit the company as a separate person to own property, enter into contracts, or sue or be sued by other parties in its own name. And then the second characteristic is legal liability, limited liability. That means shareholders are generally liable only up to their investment, and personal assets are ordinarily protected. So Dilini will not lose her personal properties. I believe it's clear, right? And what you can do is I will explain all the answers. And if you have further questions towards the end, I will answer if I have some more time. Okay, right. Then, second part, evaluate whether continuing as a sole trader or incorporating a private limited company would be more appropriate at this stage. Support your conclusion with reasons linked to the scenario. I have already done it, but now we have to put it as an answer. So structuring the answer. Do not waste a lot of time writing lengthy paragraphs. Explain it in bullet points. So here 4 marks are allocated. What you have to do is evaluate. Now, she's currently a sole trader. Whether she should convert her business into a private limited company would be more appropriate. My answer, I'm sure that you, from what I explained, you would have already gathered that answer. Yes, it's more appropriate to convert this sole trader business into a company, considering the liabilities and serious contracts that she's going to enter into. So support your conclusion. Oh, okay, my conclusion is yes, this should be converted into a private limited company. Then I have to explain myself, my conclusion. That is why I am saying Dilini should convert this business into a private limited company. And those reasons I should link it to the scenario. Understand the question that you have been given and accordingly give a perfect answer. Then you are going to get full marks. So incorporation, first line, converting the sole trader business into a company, into a private limited company is more appropriate here. Then explain why. Support it. Support your conclusion. One reason is she's going to obtain a significant amount of money from a bank, 80 million rupees. Being a sole trader, borrowing 80 million is a substantial amount. So you're going to obtain a bank loan of 80 million, a significant amount. So why it is good to convert your business into a company? Because to protect your personal assets. If something goes wrong and you fail to settle this, you may have to sell your personal assets to settle the liability. But if you convert your business into a company and you enter into a contract with the bank through the company, then it is a contract between the bank and the company. You're not a party to that contract. So, considering the fact that you're going to borrow a significant amount of money from a bank makes it more suitable for you to go for an incorporation. And then bringing new investors, you can avoid conflicts and a lot of other problems when you incorporate a company, and it's easy to attract investors also because all of you can become shareholders rather than being partners and having unlimited liabilities, because the nature is such when you run a business as a partnership, it is I mean, most of the time, people have conflicts, disputes, and it's very difficult to resolve those disputes as well because you have a partnership ordinance rather, with only 50 sections in it, and that is actually not enough to solve all the problems. But on the other hand, you have a very serious Companies Act, and considering the new amendment brought in also that have become a lot of, more complicated. So you have a very proper legislative or statutory enactment to resolve any of the problems that you're having. So it's easy to encourage people to invest in your company because they can straight away come as shareholders. Only a company can issue shares. So they can come as shareholders. Then you're going to have a professional operation manager, because if you recruit as your employee, you take personal responsibility for that person, but now you convert into a company. Now the company is hiring it. If he's going to sue one day as an employee, he will have to sue the company, and the company should sue him if there is any problem. And even the suppliers are usually happy to deal with a company rather than an individual. So, because of those reasons, it is uh, ideal for Delaney to convert his business into a private limited company. Through that, you can actually the underlying principle is that you can avoid unlimited liability. You can avoid unlimited liability, and that will allow you to basically uh, maintain your reputation, because the company is the real face. The company is the one entering into contracts in this situation. Okay, right. Now, B, analyze the legal implications and risks relating to proposed pre-incorporation contracts. So there are two aspects to this question, and advise Delaney on the protections available if the company subsequently adopts these contracts. Now it's important here. Okay. Now, one second. Right. I believe you have heard about pre-incorporation contracts. This had been a tricky area in the past, but with the introduction of number 7 of 2007 Companies Act, things have changed. I know you guys don't have to be familiar with the UK company law, but most of the cases now, even if you take the very first case that you learn, Salomon versus Salomon and Company, that's a UK case. It's a UK judgment. So when you talk about Sri Lankan company law, it's inevitable that you should be familiar with English case law as well, because most of the principles we learn from those English uh, judgments and English legal principles relating to company law. But this is an area that is now completely different from the UK law. I'll explain why. But first of all, we'll try to understand the meaning of pre-incorporation contracts. Right. Analyze the legal implications and risks relating to proposed. That's what I'm going to answer now. Now, a company has to be incorporated. A company has to be incorporated. A company should be born. Now, as natural persons, we came to this world. We have a date of birth. We were born to this world. Right? Likewise, a company should be born. Like we have a date of birth, a company has a date of birth. You call it date of incorporation. Where do you see this date of incorporation? You see it in the certificate of incorporation. Like we have a birth certificate, a company also has a birth certificate. We call it a certificate of incorporation. Certificate of incorporation. It has the date of birth. We call it the date of incorporation. However, to incorporate a company, there is a procedure that you have to follow. You have to submit the relevant documentation to the registrar of companies. If you're going to start a private limited company, there is an application or registration form which is known as Form 1. Then every company should have a director or directors. So if you have 2 directors, each director should give their consent to be a director in that company. So Form 18. There should be a company secretary. Secretary should give his or her consent to be a secretary or to function as a secretary of the company. There you have another form which is known as Form 19. So these are the basic forms that you need to submit when you are incorporating a company. Form 1, Form 18, Form 19. Then, company should have a constitution, the most important law which is applicable to a company. A company is governed by its constitution known as Articles of Association. There are several separate part to govern Articles of Association of the Article Association of the Companies Act. So you guys are familiar with those things. So what you should do is look at the study notes, and you can highlight the relevant sections that are applicable to you guys in the syllabus, because not each and every section is applicable to you. So since you have the opportunity to underline, sideline, and highlight, use it. Make sure you can tab them as well. So do that now itself. That will be very useful, and it will save a lot of time, because sometimes it will give some confidence when you hear the fact that it's an open book test. But mind you, remember that if you have not gone through the Companies Act previously, it's not something. It is impossible for you to do that during the examination, because you have only very limited time, right? Okay. Now, so here, Articles of Association. Articles of Association. So there's a chapter for that. There's a separate part for that. So this is a very important area. So this is the constitution of the company. So coming back to what I have been explaining, right? So you have to submit those documents to the registrar of companies. Before any of those, first you need to decide of a name for your company. Like we all have names. So when we were born to this world, they gave us a name. So that is a name that we are using. So people call me Rakita because that's a name that my parents gave me. Likewise, a company should have a name. Before submitting any of these documents, first of all, you should get a name approval. That is also an area governed by the Companies Act. Please highlight the relevant sections in the Companies Act. Name approval. Because you can't have any name you like. Now, that will confuse the society. These are for very practical reasons. Now, if there's another person with the same name, now in a class also, if you have 2, 3 people with the same name, when somebody wants to address, when your lecturer wants to address, then all three will get confused. So to avoid that to avoid that kind of confusions, what we do is we make sure that a company has a name which is not similar to another company, which is similar to a name of another company. So you get the name approval, you submit the documents, and within 2, 3 days, you will be able to get your incorporation provided you submit all the relevant documentation. Let's say 1 week. So you submitted the documents, let's say today. Sorry, I take another date. Right. So 1st May, you submitted the document this year. And then you get the certificate of incorporation on the 7th of May. And the incorporation certificate has 5th of, you received the certificate of incorporation on the 7th of May. But you received it. But the certificate of incorporation has 5th of May as the date of incorporation. Submitted date not relevant. The date that you received the incorporation is irrelevant. What matters is the date that appears on the certificate of incorporation. In my example, it is 5th of May. Therefore, the date of incorporation of this company is 5th of May. The company was born on the 5th of May. Until then, there was no company. Then a practical question arises, especially in a situation like this. You have an existing business where you have been running it as a sole proprietorship. Now only you want to convert into a company, but there had been previous arrangements. You have entered into contracts in your personal name in the past. You have started personal bank accounts. So if you take all those things have happened prior to the incorporation of the company. And not only that, isn't it practical? Now you want to start a company. Assume that you don't have any existing business, you want to do it for the first time. You go and meet a professional like a chartered accountant who's running a company secretarial firm. You say, I want to start. So don't you have to pay his fees? Sometimes they will ask you to pay the fees upfront. But do you have a company to enter into that? Isn't that a contract? Contract with the company secretary. You have to pay him for the incorporation. You pay it from your pocket. But you're doing it to incorporate the company. But the company is still not incorporated, but you have entered into a contract already and paid money according to that. You meet some suppliers. You don't want to wait until the company is incorporated. You think that I should prepare myself straight away to start the business. You try to find new customers. You try to find new suppliers. Even in this situation, you try to find new investors. You enter into agreements with those people. You want to get a telecommunication, a connection, a CERT connection, or else you want to get, let's say, electricity connection, water connection. You take all those things, but the company is not incorporated, and you have signed signed for the time being. You have signed all the contracts. Now, those contracts are known as pre-incorporation contracts. Entering into a contract with the company secretary. So all those things are considered as contracts prior to the incorporation of the company. We call them pre-incorporation contracts. Pre-incorporation contracts. Now the question is, who is liable for the pre-incorporation contracts? Who is liable? The law prior to 2007 Companies Act was that the person who entered into those contracts was personally liable. was personally liable. Now, the principle in the United Kingdom is that still that is the case. Pre-incorporation contracts cannot be ratified or adopts. Cannot be ratified, UK. Even though you like it or not, a company after incorporation cannot adopt those contracts in the United Kingdom. Remember, don't make mistakes. Don't listen to me halfway and get wrong conclusions. Don't get wrong understandings. This is in the UK, I mentioned. UK is very clear about pre-incorporation contracts. The person who entered into the contract prior to the incorporation of the company should take personal responsibility. Company has no responsibility whatsoever according to the law. Even though the company wants to adopt them. What do you mean by adopting those contracts? That means, okay, we call it in law of contracts, we call it novation. Don't think too much about it if you haven't heard those concepts, right? So now Delaney has entered into a contract, let's assume with a company secretary. Entered into a contract with a company secretary. Company is now incorporated. It has come into effect on the 5th of May. So a company is born. The company, even though the company wants to, this is in the UK, even though the company wants to, the company cannot become a party to this contract. Delaney has to take personal responsibility. If the company is permitted to adopt, that means instead of Delaney, company is going to be a party to this contract. So you will have to have a fresh contract. That's the ideal thing to do with the company secretary. You can have a fresh contract, or else by way of novation, you can introduce a new party to the contract. So anyway, that is the situation in the UK. Even though the company likes to do it, a company is not permitted to do it simply because under law of contracts, an unborn baby cannot enter into any contracts. Can an unborn baby is not born. Unborn baby is not born yet. You can't enter into contracts on behalf of an unborn baby because we don't know whether it will happen or not. This is coming under law of contracts. That's the principle in the UK. Therefore, if someone has entered into a contract on behalf of an unborn baby, like Delaney entered into this contract on behalf of the company that she was planning to incorporate, unborn company, UK position is that no, company was unborn then, company was not in existence at the time of the contract. Therefore, the company cannot adopt or ratify something that happened when the company was not in existence. Assume this contract was on the 30th April. Company was not there on the 30th of April. It came into effect on the 5th of May. But Sri Lankan situation has completely changed from what we had earlier before the introduction of 2007 Companies Act. Now I'll straight away explain. I just wanted to explain something extra for you guys to have I can straight away give you the answer, but I'm trying to explain the legal principles behind it. So assuming that you guys will have a better understanding about it. So that's I'm taking extra time. So anyway, now here, what I wanted to explain is that the situation in Sri Lanka is now completely different. Yes, if someone has entered into a contract on behalf of a company which is going to be incorporated, we call it pre-incorporation contract. And the party who entered into the contract, in this instance, Delaney has to take personal responsibility. However, the moment the company is incorporated, unlike in the United Kingdom, in Sri Lanka, the company has an obligation under the Companies Act to adopt those contracts. Delaney doesn't have to make a request. The company has the obligation to adopt those contracts and take responsibility for those contracts and to release Delaney from from those obligations. Now, there is a separate area in the Companies Act relating to pre-incorporation contracts. Here, pre-incorporation contracts. So you should refer to this section and gather the relevant parts and explain Delaney's responsibility for these pre-incorporation contracts mentioned in the question. For the purpose of this section and sections 24 and 25, the expression pre-incorporation contract means, okay, even the definition is here, a contract purported to have been entered into by a company before its incorporation, or a contract entered into by a person on behalf of a company before and in contemplation of its incorporation with the expectation that it will be incorporated. Notwithstanding anything to the contrary, anything to the contrary in law, a pre-incorporation contract may be ratified means adopt. In a contract, if no such period is specified within a reasonable time after incorporation, this is what I said. Now the law is that under the Companies Act number 7, 2007, once a company is incorporated, if there is a time period already mentioned for the company to incorporate it, that has to be done within that time period. If there's no such period, then the company should take steps to within reasonable time, the company should take the responsibility for those contracts in the name of which or on behalf of which it has been entered into. Here, this is the outcome. A pre-incorporation contract that is ratified under subsection 2 shall be as valid and enforceable as if the company had been a party to the contract. So once the contract is ratified, adopted by the company, previous person Delaney will be replaced with the name of the newly incorporated company. So the newly incorporated will become the party to the contract and will take all the obligations under the contract. Delaney will be released from her obligations. But what if the company, you don't have to explain any of all these things because it's only 3 marks allocated. Remember, let's assume the company fails to do this within a reasonable time. Company doesn't do it at all, but still doesn't matter because there are warranties implied in pre-incorporation contracts. What is that? This is to protect people like Delaney here in this example. To protect Delaney from taking unnecessary responsibility, because this was done by Delaney not for herself but for the company that is going to be incorporated. So we don't want to penalize a person who did something on behalf of another party. But that's not the situation in the United Kingdom because they are very strict about their legal principles. Here we think in a different way. We think she did it on behalf of the company. So let's get the company to take the responsibility because it was done on behalf of the company. That's the position in Sri Lanka. So what if the company after incorporation doesn't ratify or doesn't adopt the contract, but still doesn't matter? The law gives a protection to the person who entered into the pre-incorporation contract. How do they give that warranty? This is how it is worded here. Notwithstanding anything to contrary in any law, in a pre-incorporation contract, unless a contrary intention is expressed in that contract, there shall be an implied warranty by the person who purports to enter into such contract in the name of or on behalf of the company that the company will be incorporated within such period. So Delaney, when she was entering into the contract, she thought soon the company will be incorporated. So she's entitled to think like that. If no period is specified within a reasonable time after making the contract, and that the company will ratify the contract within such period as may be specified in the contract, of no period is specified within a reasonable time after the incorporation contract. So the amount of damages recoverable in an action for breach of an implied warranty referred into subsection 1 shall be the same as the amount of damages as may be recovered in an action against a company for damages for breach of company. Now, what I will explain straight away what it means, because we need to discuss the other questions as well. So, simply, Dilini will be exonerated from her obligations once a company is incorporated. Please refer to the relevant sections. Please refer to the relevant sections, and you can even extract the relevant parts from the sections and explain it. But simply, she had the personal responsibility. But once a company is incorporated, the company should ratify those contracts or adopt those contracts within a reasonable time period. And Dilini can presume that the company, at the time of entering into the contract, she's entitled to assume that the company will be incorporated, and afterwards the company will ratify. If that doesn't happen, and if Dilini has to take personal responsibility for any of those pre-incorporation contracts, she can recover damages from the company, what she had to go through. So that is how it works in Sri Lanka with regard to pre-incorporation contracts. Then we'll straight away look at question number 2 as well. So you are a company secretary of Horizon Energy PLC, but before that, let me see what we have to answer here. Required: analyze the governance and procedural requirements that Horizon Energy PLC must follow in order to proceed with the proposed borrowings. Okay. Evaluate the governance consideration arising from the appointment of Ms. Rashmi Silva as an independent director and the removal and replacement of the chief executive officer. Applying the solvency test under the Companies Act number 7 of 2007, assess whether the proposed dividend may legally be declared and justify your conclusions. Okay. So we know that, I mean, by looking at the question, we can get some kind of an idea what they're going to ask here. Let's now read the facts. You are a company secretary of Horizon Energy PLC. The board is considering a major expansion project involving the construction of a solar power plant in Hambantota. The board intends to borrow USD 12 million from a foreign bank. Appoint Ms. Rashmi Silva as new independent director. Remove the current chief executive officer due to poor performance. Declare a final dividend of 150 million to shareholders. You review the articles of association and observe that the board's borrowing powers are limited to 8 million USD unless shareholder approval is obtained. So that's how it works. That is how it is set out in the articles of association, which is the constitution of the company. Then further financial information: current assets after proposed dividend, 420 million. Current liabilities after proposed dividend, 100 million, 400 million. Total assets after proposed dividend, 1.2 billion. And total liabilities after proposed dividend, 1.15 billion. Okay. Let's look at the first question. Analyze the governance and procedural requirements that Horizon Energy PLC must follow in order to proceed with the proposed borrowing. So it's about this proposed borrowings. The question is very clear. The constitution of the company permits you to borrow maximum amount of 8 million as the board of directors, unless shareholders approve. So it's very clear. Your requirement is to borrow 12 million USD. 12 million USD. So the existing articles of the company do not permit you to, as board of directors, it doesn't permit you to borrow more than 8 million USD. Try to understand this. In a company, in a company, the shareholders are the owners. But unlike in a sole proprietorship or else a partnership, the owners cannot get involved in the management of the company. When I'm explaining like this, think of a public limited company, a listed company in the stock exchange. Let's assume commercial bank, commercial bank. There are thousands and there are thousands of shareholders in the company. Now, they are the shareholders, they are the owners of the bank. But can those shareholders get involved in the management of the company? Not at all. It's completely prohibited. It's not permitted. It's not allowed, even by the law. But in a partnership, partners should be able to get involved in the management. That's a right given to them. But in a company, shareholders have no right to get involved in the management of the company because the management of the company is done by the board of directors. Out of shareholders, you can appoint a group of people who are competent, who have knowledge to manage the business. We call them the board of directors. So in a company, the ownership is with the shareholders, but the management is with the ownership is with the shareholders, but the management of the company is vested with the board of directors. I'm sure that you have learned the case Royal British Bank versus Turquand. We call it Turquand rule. There it clearly there it's again it's a English judgment which says the management of a company is vested with the board of directors. The shareholders cannot interfere with the management of the company. You have to allow the board of directors to run a company. It's like we have appointed a president, a prime minister, some parliamentarians to run the country. So not all 22 million of this of the population can't run the country, can't manage the country. It's impossible. So out of them, we appoint a group of people to manage the country for a particular period. So exactly the same principle we apply when it comes to a company. The owners are shareholders, but the management is done by the board of directors. Shareholders cannot interfere. So then a question arises, what if the board of directors do whatever they want without listening to the shareholders? Then, as shareholders, what you can do is you can remove the board of directors because who appoints directors? Shareholders. Who remove directors? Shareholders. So, if you are not satisfied with the performance, like we are going to do here, because you are going to remove the chief executive officer, so you can do that. But once they are appointed, you can't interfere with the management. You should allow them to do it. If they are not satisfied with their performance, then the remedy is to remove them and appoint a new one for that. That is permitted. But while they are holding their office as directors, you can't interfere with them. You should allow them to do their job. So, what I want to tell you, so there is a separation between the ownership and the management of a company. Okay. Now, the board of directors, yes, they can manage the company. Usually, they have all the authority to do whatever they want. It is there. Go to section. You can highlight these sections. So, for your later reference. Bear with me, guys. So from the Companies Act, statutorily, directors are granted power can here do the necessary things to manage the business. That power they get from expressly from the Companies Act. Yes, it's here. Wait. 181, I guess. Yeah, power of management, section 184. From this section, directors get their power, subject to the provisions contained in the articles, but the curtailment is coming from the articles. You get the power, but if the articles of association has some limitation, like what we saw here, the maximum amount of money that the directors can borrow is limited to 8 million USD, but they want to borrow 12 million USD. So the articles don't permit them, or they don't have the power in simple terms to borrow more than 8 million USD, because it's curtailed by the articles of association. The business and affairs of a company shall be managed by or under the direction or supervision of the board of the company. The board of a company shall have all the powers necessary for, this is where you get all the powers necessary for managing and for directing and supervising the management of the business and affairs of the company. Right? But so you get all the powers, but subject to what? Provisions contained in the articles of the company. So refer to this section in your answer. You can do, the power is given to you to manage the business in the way you want, but it is restricted by the articles of association of the company. But what the articles of association says here? Articles of association says the board of directors have the power to borrow 8 million USD, but you want to borrow more than that. If you want to borrow more than that, what you should do, you have to take the approval of the shareholders of the company. You have to take the approval of the shareholders of the company. You take approval of the shareholders of the company. Now, here, what you have to explain is a simple thing. I just wanted to explain from where you get the answer, right? So, simple, since borrowing exceeds the limit in the articles, shareholder approval should be obtained before proceedings. So, proper proceedings means you need to have proper board resolutions and compliance with the constitutional provision. So basically, you have to call for a meeting of the shareholders of the company to obtain their approval. So the notices should be sent to the shareholders of the company, calling for a meeting. You can have a meeting in lieu of a physical one. You can have a resolution in writing, so something that is possible, or else you have to call for a meeting of the shareholders and present a resolution to the shareholder for the present a resolution for the approval of the shareholders of the company. Present a resolution for the approval of the shareholders of the company. Once the approval is granted, then only you can proceed to enter into any contract to borrow any sum of money exceeding USD 8 million. And one more thing, uh, here the information not very, clearly doesn't indicate that. You don't have to mention but I'm just pointing out this as well. Sometimes the money that you are going to borrow may fall within the scope of major transactions. Within the scope of major transactions. So if you are going to borrow money here, uh, which exceeds half the value of the assets of the company. If you're going to borrow money, see, a transaction which has or likely to have effect of a company acquiring rights or interest or incurring obligations or liabilities of a value which is greater than half the value of the assets before the acquisition. So here the assets are given in USD, and then the value is given in, the asset values are given in rupees, 400, 1.2 billion. And then uh, here the money that you're going to borrow is USD 12 million. So we don't have to convert and do it, because they ask you a simple question here, what they should do before borrowing this money. Because here the constitution is very clear. It says if you are going to borrow money more than USD 8 million, you have to take shareholders approval. So you should take steps to follow the procedure to obtain the approval of the shareholders and do it. But I just wanted to point out additionally, not relevant to not relevant in answering this particular question, but not relevant in answering this particular question, but sometimes you may have to consider the aspect of major transactions. So if you're going to borrow money which exceeds more than half the value of the assets of the company, here in this example, total assets 1.2 billion, half is 0.6 billion, that is 600 million. 600 million. So in this instance, 12 million, that is what you have to borrow. One second, guys. Yeah. So it can be actually more than what you're going to have. But so anyway, don't think too much about that. But anyway, if we are going to borrow money more than half the total assets of the company, that falls within the scope of major transactions. In such a situation, anyway, the board has no power to proceed with that transaction unless you get the shareholders' approval by passing a special resolution. That's the procedure when it comes to major transactions. If you want in your answer, you can mention that as well. But we don't have enough information to evaluate that. You can say one thing is very clear: articles do not grant power to the board of directors to borrow money beyond USD 8 million. Therefore, they have to call for a meeting of the shareholders to obtain necessary approval to borrow USD 12 million. If they refuse, you can't proceed with the transaction. In any way, if it falls within the scope of major transactions, then still the shareholders' approval is required. But in that case, it has to be done by way of a special resolution. You know the difference between an ordinary resolution and a special resolution. If the act says you need a special resolution, you need 75% of the consent or the approval of the shareholders of the company. But if it is an ordinary resolution, you need a simple majority. But in this instance, if it doesn't fall within the major transaction scope, then you will need whatever the approval required by the shareholders of the company. So it might be either special resolution or ordinary resolution. It depends on what you have in the articles of the company. So the answer to this question is basically uh, you need to get shareholders approval and the governance procedure, because it says governance procedure requirements, to have a proper board resolution and explaining the nature of the transactions and why do they require approval for this transaction, and then uh, preparing a shareholders resolutions and calling for a meeting of the shareholders to obtain their approval. Notice must be given, meeting must be called, and resolution must be passed. So that's how it should work. Then evaluate the governance considerations arising from the appointment of Ms. Rashmi Silva as an independent director and the removal and replacement of Chief Executive Officer. These are not complicated, difficult questions. But you should know from where to gather what the relevant provisions applicable if necessary. So here, to appoint an independent director, they're asking about the governance considerations. I'm not. So governance consideration, I must tell you, you have to be very careful. These are not about the procedure that you have to follow to appoint a director. This is coming from corporate governance. Why do you need to appoint an independent director? Because it increases or it strengthens objective oversight and accountability. It strengthens objective oversight and accountability. It strengthens, write it down, objective oversight and accountability. Appointing a director has to be done, of course, again in compliance with the Articles of Association and the statutory provisions of the Companies Act. Right? So here, remember, you have to be very thorough when it comes to the duties of directors. That's extremely important, right? You can appoint any person who is not disqualified to be a director of the company, usually by passing an ordinary resolution. But if the article says no, you require more, then you have to work according to that. Here, a person who is a director of a company on the appointed date, appointment and removal of directors. I'm just addressing this. But the answer to this question is, why do you need a NED, a non-independent, independent director, a NED, non-executive director, plus an independent director? That is to strengthen objective oversight and accountability. Basically, answer to that question is that. But I'm just going away from that because these are the things that you should be familiar with. A company shall have at least one director, except a public company should have at least two directors. A person who's not disqualified under subsection 2. So here, section 202 gives you a list of things that a person will be considered to be disqualified to be a director. So a person who's under 18 years of age can't be a director. So likewise, our Companies Act doesn't say the qualifications that you should have to be a director. It gives you a list of disqualifications. If you don't have any of those disqualifications, then you are fit to be a director of any company, subject to certain regulations. Now, if you want to be a director of a bank or listed company, and if you want to be a director of finance, then there are certain requirements coming from the rules and regulations set out by the Colombo Stock Exchange and the Securities Exchange Commission, sometimes coming from the central bank. Likewise, there are other obligations. But if you look at the basic requirement is, if you are not qualified under section 202, then you are fit to be a director of a company. That's the basic requirement. But anyway, company, through their articles of association, they can introduce new requirements how a director should be appointed. So anyway, then what about the removal and replacement of the chief executive officer? Now, when you're removing a chief executive officer, one hand, if he's a director of the company, if the CEO, some companies, CEO is not a director actually. He goes for board meetings. Sometimes he's not a director of the company. But let's assume here, chief executive officer is also a director of the company. In that case, he should be removed as per the articles of the company. Removal of a director here. This is how you can remove a director. So in this instance, assuming that the CEO is a director of the company, subject to the provisions contained in the articles of the company, a director may be removed from office by ordinary resolution passed at a meeting called for the purpose or for the purpose of that include the removal of the director. So you just need to pass a simple ordinary resolution to remove a director. That's the requirement. Ordinary resolution. But through the articles, you can have higher requirements as well. That's why it says subject to the provisions. If the articles do not have separate provisions, then you just need an ordinary resolution to remove a director. But there's one more thing. Unlike other directors appointed, when there is a CEO, he's the one who represents the company. He's the one who enters into contracts on behalf of the company. Chief Executive Officer, the president of the country, like that, similar to that. There, usually you have a separate contract. You usually have a separate contract. Now, this is governed by law of contracts. A letter of appointment given to the chief executive officer. True, since he's a director, if he's a director, you can remove him by passing an ordinary resolution. But additionally, if you have issued a contract of appointment contract or contract of employment to the chief executive officer, if you suddenly decide to remove him, there might be a breach of contract. Assume the chief executive officer is appointed for a period of 3 years. He's appointed for a period of 3 years. But now suddenly you have decided his performance is poor, so we are going to remove him after now 2 years' time. He has 1 more year to continue according to the contract. So then there's a possibility that he would take legal action against for breach of that contract. Of course, if you lose, you will have to pay compensation. But if the contract uh, uh, permits you to go for an early termination, like in this situation, 3 years, now you want to remove him after 2 years, can be done in compliance with the contractual obligation. So in your answer, address both. If the CEO is a director of the company, he can be removed by passing an ordinary resolution subject to any other provisions in the Articles of Association in terms of 206. But at the same time, you have to comply with the contractual obligations and good performance procedures before removing him as a chief executive officer, because otherwise he can take legal action against the company. Right. Then the next one, applying the solvency test under the Companies Act number 7 of 2007, assess whether the proposed dividend may legally be declared and justify your conclusion. There's a simple computation that you have to done. You know the solvency test requirement. Now I have to go little fast because I have to allow the next resource person to do his part also. Yeah. Okay. A company shall be deemed to have satisfied the solvency test. There are two things you have to do in order to satisfy the solvency test. You guys are accounting people, so of course familiar with these simple computations. You guys do complicated ones, so it's a very simple computation. How do you satisfy the solvency test? If these two conditions are satisfied, it is able to pay its debts as they become due in the normal course of business. So refer to section 57 and say a company shall be deemed to have satisfied the solvency test. You can actually reproduce this and do the computation. If it is able to pay its debts as they become due in the normal course of business. Now that information is not given to you, but you mention and assume this condition is satisfied. Then the value of the company's assets is greater than the value of the liabilities and the company's stated capital. In determining whether a company satisfies the solvency test, the board shall take into account most recent financial statements. Now, in this instance, you look at it here, what mattered is total assets is greater than the value of liabilities and the company's stated capital. So here, total assets is 1.2 billion, total liabilities after proposed dividend 1.51. So you can come to a conclusion total assets exceeds total liabilities. Even if you look at current assets, obviously, if total assets exceed, then you're okay. Even if you look at the liquidity position of the company, whether you have enough cash to pay a dividend, then current assets also in excess of current liabilities. So we can safely come to the conclusion that this company satisfies the solvency test. Satisfies the solvency test, assuming that the company can pay its debts as they become due in the normal course of business. Here, the company's stated capital is given. Therefore, all the information required to do this computation are not given. But in such a situation, what we have to look at is the liquidity position to pay dividend and the total assets position of the company. Accordingly, it's clear the total assets of the company are in excess of total liabilities, and the current assets also in excess of current liabilities. Therefore, they are in a position to pay their dividend. So you can come to a conclusion. The proposed dividend may legally be declared in this situation as their total assets are, so one is balance sheet test and the liquidity test, both are basically passed here. But ideally, you should have these information to clearly satisfy the solvency test. I'll do a simple computation here. Ideally, it should be like this. The company's assets, we'll assume the company has total assets 200 million and liabilities, let's assume company's assets are greater than value of liabilities and company's stated capital. They only take company's stated capital, right? So liabilities will assume 150 and stated capital will assume 30. So total liabilities plus stated capital is 180. So the total assets are greater than value of liabilities and company stated capital. So definitely you satisfy the solvency test, provided you are in a position to pay all debts as they become due in the normal course of business. But if you have a situation like this, stated capital 60, then $210. That means your assets are not adequate enough to settle your liabilities and to the shareholders of the company. That is what it means. Your assets are not adequate. This is the situation that the company is insolvent. Correct? A solvency test. So you have more liabilities towards the outsiders and to the shareholders than what you have as assets in the company. This usually happens when your reserves are negative. When you have accumulated the funds negative, reserves are negative, this can happen. Then the financial position of the company deteriorates. So anyway, you guys are familiar with it, but I just wanted to explain the financial aspect of it as well, so then you can understand it better. Then we come to the next part, next question. So here, based on the information given, you can say solvency test is satisfied, therefore a dividend declaration can be done. Yeah. Third compulsory question is, analyze the key implementation steps involved in carrying out the proposed spin-off and explain how the transaction may affect shareholder value. Assess the legal and governance implication arising from the proposed purchase of land from Mr. Jayasuriya and advise minority shareholders regarding any remedies available under company law. Evaluate high digital tools. Evaluate one second. High digital tools and data analytics may support. Now, this is also part of your syllabus, so that's why this question is included during the restructuring and integration process. Right? Now, Blue Wave Logistics Private Limited is a Sri Lankan private limited company engaged in freight forwarding and warehouse management. The company intends to attract foreign investment to expand its regional operations. The board proposes the following: spinning off its warehouse division into a separate company. Spinning off is using one product and then converting into something different. Spinning off a warehouse division into a separate company now. Issuing shares to Singapore-based investor who will acquire 40% of the new company. Purchasing land from one of the directors, Mr. Jayasuriya, who construction of a logistic hub. Using digital project management and analytics tools during the restructuring process. Some minority shareholders have raised concerns that the proposed land purchase price may be significantly higher than the market value. Now, that question is important because you're going to purchase that land from whom? From a director of the company. So, this is about duties of directors, that particular aspect of the question. Analyze the key implementation steps involved in carrying out the proposed spin-off and explains how the transaction may affect the shareholder value. Now, this is something that you have learned in other subjects also. So, now it's important company engage in freight forwarding and warehouse management. That is your business. That had been your business. Now what you're going to do is you're going to convert that warehouse into a separate company, and you're going to issue shares to a Singapore-based investor who will acquire 40%. Now, when you're going for a spin-off like this, remember, you have to value this division. A valuation has to be done. When you're going to convert into a separate company, there should be a valuation of the warehouse, because that is what is going to be a company now, and it will become the value of the new company. So a valuation of the warehouse division has to be done. And to convert this into a different company, you need the board approval. This is a separate asset of the Blue Warehouse Logistics Private Limited. Blue Wave Logistics Private Limited has a warehouse, a separate division. So that whole division is basically an asset of the company, that division. That division contains, we don't know, since it's a warehouse, there of course should be a building, other machinery, people who are working in that division. So all those belong to Blue Wave Logistics Private Limited. Now that division, we are going to take it away from Blue Wave Logistics Private Limited, and that is going to be converted into a separate company. In other words, this warehouse division will be sold to a new company. Therefore, since it's part and parcel, currently it's part and parcel of Blue Wave Logistics Private Limited, before selling it to this new company, before converting it to a new company, a valuation has to be done, identifying what are the assets and liabilities of the warehouse, what are the assets and the liabilities or the obligations attributable to this warehouse division, because that is going to be, those are going to be the assets and liabilities of the new company. So board approval is required. Transfer of these assets and liabilities to the new company. And accordingly, new shares will be issued to the prospective investors, including this share-based division company. Then what will happen is, this will unlock shareholder value through operational focus. So what happens is, this is actually coming from, because you try to understand this subject, your subject is corporate entities, formation, governance, and legal framework. Not just the Companies Act. You have arbitration also. So all those things are there. Accordingly, how can you explain how the transaction may affect the shareholder value? Because the assets and the liabilities of this particular division will now be transferred to a different company, and accordingly the new shares will be issued to prospective investors, and that will have an impact on the shareholder value of the new company as well as the existing company. Actually, the shareholder value of the existing company will go down. Instead, that value will be transferred to the new company. Then assess the legal and governance implications arising from the proposed purchase of land from Mr. Jayasuriya, and advise minor shareholders regarding any remedies available under company law. Now, this is a serious situation. What has happened there? He's a director of the company. The company is going to purchase a land from him. According to the minority shareholders, the company is planning to pay more than the market value. Let's assume the market value is 10 million. Sorry, the value that we are paying is 10 million. The market value is 8 million. So you are paying 2 million extra to purchase this land. If you buy it from an outsider, you have to pay 8 million. But you are buying at a higher price, exaggerated value, because he's a director of the company. So this is governed by duties of directors. It is governed by duties of directors. Accordingly, remember, you have to refer to the relevant provision here. Duties of directors, 180s. Directors cannot earn secret profits. It's very clear. The directors cannot earn secret profits using their position. They have a fiduciary duty. They have to act in utmost good faith. They have to act in the best interest of the company. Now, this particular director is gaining a secret profit by selling his land to the company at a price above the market value. It doesn't mean that a director cannot sell or buy assets from a company. Can. One hand, it must be disclosed. Remember, a director can get involved in transactions of the company, but you have to disclose it to the other directors of the company, and you should allow them to decide whether to buy the land from this person or not. However, even though the company proceeds with the transaction, remember, director cannot have any secret profits, because the director has to act in utmost good faith towards the company. He has to forget about his personal interest. He has to always prioritize the interest of the company. Okay, here, a person exercising powers or performing duties as a director of a company shall be, in your answer, mention this. A person exercising powers or performing duties as a director of a company shall act in good faith and subject to subsection 2 in what person believes to be in the interest of the company. So subsection 2 is not applicable here. A person exercising powers or performing duties as a director of a company shall act in good faith and subject to subsection 2 in what that person believes to be in the interest of the company. So if he proceeds with the transaction, he will be in breach of that duty. And here, remember, there's another duty that you can mention. He has a personal interest in this transaction. He has a personal interest in this transaction because he's selling, the relevant director is selling his land. Therefore, here, a director of a company shall fall with after becoming aware of the fact that his interest in a transaction or proposed transaction with the company caused to be entered in the interest register, and if the company has more than one director, disclose to the board of company the nature and extent of the interest. That's why I said it doesn't mean that the company cannot buy or sell properties to a director. It can. But if a director knows that he's personally involved in a transaction through him personally or probably through a relative of him, that interest he has to disclose it to the company. And if there are other directors, should disclose it to the other directors of the company. So this is how it should be disclosed. For the purpose of subsection, a general note is entered in the interest register or disclosed to the board to the effect that a director is a shareholder, direct officer, or trustee of another named company, or that person or is otherwise connected with another company, or the person be regarded as interest in any transaction which may after the date of the entry. So anyway, be that as it may. So if you have a personal interest in a transaction, you have to disclose it to the company and to the other directors of the company. What happens if you fail to do that? A failure by a director to comply with the requirement of subsection shall not affect the validity of the transaction entered into by the company or the director. However, every director who fails to comply with the requirement of subsection 1 shall be guilty of an offense and be liable on conviction to a fine not exceeding. This is the outcome. And other thing that you can mention now, the board of directors should make a decision to buy this property from this particular director. Now, that's a board decision that they have to make. In making that board decision, remember, he should not take part in making that decision. If you have 4 other directors, you should allow the other 4 directors to make the decision whether the company should enter into this contract or not. He should not get involved in that transaction. A transaction entered into by the company in which a director of the company is interested may be avoided by the company at any time before the expiration of 6 months after the transaction, and the directors interested in it have been disclosed to all the shareholders of the company. Right. Anyway, that is how you should answer that particular question. Then there's one simple one. Evaluate how digital tools and data analytics may support management during the restructuring and integration process. The simple answer to that question is that uh, digital tools support project management here, project management. This is a special project that they're going to do. So accordingly, these digital tools and data analytics support project management, communication, forecasting, and data-driven decision here. So for that, actually, please look at the what is your the text that you guys have been given, right? And 1 second, you can write it down when I'm giving the answer. So this this digital tools and data analytics basically assist uh, planning, forecasting, project monitoring, and communication during restructuring. I'll repeat, just one mark. They assist planning, forecasting, project monitoring, and communication during restructuring. So quickly, I have to allow the other lecturer to proceed with his discussion as well. Therefore, quickly I will answer question number 4. Uh, so this there are actually two questions are there. So I will give you the answers because the answers will be shared later. But I will give you the answers. So there are two questions in section B, out of which you have to answer only one question. But you allocated 25 marks. So the first three questions, short answers basically, 10 marks each. So 30 marks. And for this, 25 marks, altogether 55. But you have a choice here. You have to answer only one question out of two. So we'll quickly answer these two questions as well. You are the legal and compliance manager of Silverline Manufacturing Private Limited, a company engaged in the manufacture of a packing material. Over the past 2 years, Silverline has experienced severe financial difficulties due to rising raw material cost, reduced export demand, and significant foreign exchange losses. The following matters have been identified. The company has defaulted on several supplier payment amounting to rupees 38 million. Defaulted payment. These are solvency issues. A bank has issued a statutory demand relating to unpaid 55 million secure by a floating charge. Employee salaries and EPF obligations remain unpaid for 3 months. One director has continued entering into new contracts despite clear indications that the company may not be able to meet its obligations. This is either fraudulent trading or wrongful trading. Annual returns and statutory filings have not been completed for 2 years. Failure to compliance with the provisions of the Companies Act. Several shareholders are demanding that the company cease operations immediately. So clear signals of insolvency. In addition, Silverline entered into a supply agreement with Alpex Retail Limited in 2024. A dispute has now arisen regarding allegedly defective goods valued at 8 million. The agreement contains an arbitration clause providing arbitration in Singapore. So, selected financial information. So, anyway, let's see. 12 marks allocated for the first part. Okay. One second, guys. Yeah, okay. Now, applying the Companies Act number 7 of 2007 as amended, analyze the legal implication of Silverline continuing business operation in its present financial conditions, including possible consequences for directors. Okay. Now, since I need to save time, this is an area governed by insolvency, winding up, liquidation, and then how the liability should be prioritized during a liquidation, and also a question from arbitration here. Also a question from arbitration. Right. Now, explain the winding up options available to Silver and recommended the most appropriate course of action. Then, assuming the company proceeds with winding up, explain the statutory order prior to likely to be received by each stakeholder group. Assume all assets realized at book value, employee obligations ranked as preferential claims, liquidators cost amounting to rupees 12 million. So there are some calculations involved here. So basically 22 marks allocated for that whole part except for arbitration. Now, you have cash balances. Market value of fixed assets. So there you get 70, debtors 15, 85. So these are assets basically. You have assets here. 85 million assets. Then uh, from this, you have to bear the liquidation cost. Liquidator's cost is 12 million. Remember, in a liquidation, first of all, you have to pay the liquidator's cost. Sometimes chartered accountants also become liquidators. So remember, because the liquidator is providing a job. So after settling all the, after using the assets to settle all the liabilities, and if you're not left with anything, so in that case, in that case, you will not be, you will be left without being paid. So that cannot happen. So you have to first pay the liquidator's cost, and then you have a balance value of 73 million to settle all these liabilities. Settle all these liabilities. So you have secured bank overdraft. Remember, first you have to pay this one, secured bank overdraft, 55 million. Secured, there are secured creditors and unsecured creditors. Secured and unsecured creditors. Right? Secured creditors should be given the priority over unsecured creditors. And employee obligations, these are statutory obligations, so they should be also settled. So whatever the money that is left, first you should usually use to pay the secured bank overdraft, secured creditors, and the employee obligations. So here already you can see 55 million plus 18 million, 73 million. So you have enough assets to settle only the secured bank overdraft and the employee obligation. So these people will not be paid. Stated capital, shareholders, anyway, they have to forget about their capital. That is what we call limited liability. Unsecured creditors will be having a problem because the company does not have enough assets to settle their liabilities. So this is a typical insolvent company. Apply the company, amend, analyze the legal implication. So since it is an insolvent company, what they should do is they should immediately go for liquidation of the company. How can you do a liquidation? A liquidation can be done in three ways. There is something called voluntary, so voluntary liquidation. I'll show you that. Give you the sections for you to go through it later. Yeah, okay. You have to mention which liquidation mode is applicable here. So you can see I also made a mistake when it comes to allocating of time because I thought answering only one question in part B. That is what I had in my head, though. But even though you have to answer only one question, I have to explain the answers to both the questions. So I did a miscalculation. So anyway, I'll try to somehow give answers to both the questions. Yeah, so here, modes of winding up. The winding up of a company may be either by the court, voluntarily, or subject to the supervision of the court. By the court, voluntary, or subject to the supervision of the court. Since the company is aware of the situation, to wind up it by court, then someone should file a petition to Commercial High Court to obtain permission to wind up the company. But best thing is the shareholders in this situation can go for a voluntary winding up. So this is winding up by the court. But the ideal situation in this company is going for voluntary winding up. Yeah. So here, resolution for and commencement of voluntary winding up. A company may be wound up voluntarily where the company resolves by special resolution to the effect that it cannot by reason of its liabilities continue its business and that it is advisable to wind up. So under section 319 1C, they should go for voluntary winding up. That is the best thing that they can do. Okay. So it's situation because they have more liabilities than the assets of the company. So explain the winding up options available to Silver Line and recommend the most appropriate course of action. So going for voluntary shareholders winding up under 319 1C. Since I don't have enough time, I cannot explain each and every section, but you are required to explain the procedure that you need to follow when you're going for a voluntary winding up. A resolution for voluntary winding up means a resolution passed under the provisions of subsection 1. So basically, you have to pass a special resolution here. You have to pass a special resolution here, and then the relevant procedure is laid down thereafter. So please explain those things as well, because you are given 5 marks here and then 12 marks here. Assuming the company proceeds with winding up, explain the statutory order. Now that I have already explained, and calculate the amount likely to be received by each stakeholder group. So in this situation, when you look at the computation, those are easy marks. First, you have to settle the liquidator's cost. Then you are left with 73 million, and that money can be used to pay secured bank overdraft and employee obligations. Then the others will be paid nothing actually. They are paid, they are left paid nothing. So in that case, they have a huge risk. So that's a risk that you take usually when you're dealing with a company. And then prepare a draft email to external legal counsel instructing them to commence. This is a new area that has been introduced to your syllabus, arbitration proceedings. So here you can see there is a dispute between the two parties. Entered into a supply agreement with Alpex Retail Limited in 2024. A dispute has now arisen regarding the allegedly defective goods valued at 8 million. The agreement contains an arbitration clause. So when there is an arbitration clause, the disputes must be resolved by way of an arbitration. So there are different kinds of arbitrations. It depends on the way that you have drafted the arbitration clause in the agreement. Some arbitration clauses are there to resolve matters by referring to an arbitration tribunal in Sri Lanka, but sometimes they refer it to international arbitrations, international arbitration centers to maintain neutrality. So in this instance, the arbitration should be held in Singapore. So anyway, now what you have to do is you have to draft an email to external legal counsel instructing them to commence arbitration proceedings. So what you should have in this email, you should have you should refer to the agreement, the details of the agreement. You should refer to the relevant arbitration clause. 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 You should refer to the agreement has different terms and conditions. So arbitration clause is one of it, or several subsections might be there. So you should refer to the arbitration clause, and you should refer to the dispute value. The value is given here, and the facts surrounding the dispute, and what is the alleged breached by the parties, and what is the relief that you expect, what is the relief that you sought. So those are the essential things that you should include in an email like this when you're addressing or when you're sending an email to an external legal counsel. So defective, the supply has sent defective value goods of 8 million. So those are the facts, and that's the breach. And what is the relief that you sought? What do you need compensation? Whether you need the interest on top of that. So those things must be included in your email. So that is that actually kind of common sense as well. Then the last question. You are the senior legal advisor of Metro Tech PLC, a diversified Sri Lankan technology and infrastructure group. Metro Tech intends to acquire Innovis Analytics Limited, a smaller technology company specializing in artificial intelligence systems and industry data analytics. Don't think too much about these big words that they have used. The proposed acquisition is expected to improve Metrotech's digital capabilities, increase operational efficiency through automation, expand exports to foreign markets. However, the board has identified several concerns. Innovis has significant outstanding debts with financial institutions. Employees of Innovis are concerned about redundancies. One, Metrotech director owns 20% of Innovis shares but failed to disclose his interest during preliminary discussions. The acquisition will require substantial external fundings. Certain assets owned by Innovis include land subject to regulatory restrictions. The board requires advice on the legal governance, financial, and stakeholder implications of the proposed acquisition. Right? Okay. Then, first one, analyze the key legal and due diligence procedures that Metrotech should undertake before proceedings with the acquisition, including any relevant regulatory compliance requirements. Evaluate the responsibilities and competing interests of management, shareholders, creditors, and employees during the acquisition process. Analyze the legal consequences arising from the director's failure to disclose his interest in Innovis Analytics Limited, and advise whether the director should continue participating in board deliberations relating to the acquisition. Explain how digital tools and data analytics may be used to support planning, stakeholder communications, and post-merger integrations. Right. Now, this is from mergers, acquisitions, and stakeholder management and governance. Those are the areas covered in your syllabus. Now, they should take legal, financial, and operational due diligence here. So matters require review include what are the matters relating. You need to do a due diligence, because before you acquire another operation, another company, you need to check, because you are not only acquiring the good part of it. You are not only acquiring the assets of the company, you are not only acquiring the resources of the company, you are actually acquiring the liabilities, litigation, all the risk of that company. Sometimes they will try to exaggerate, the seller will try to exaggerate the assets of the company, the resources of the company. They will only say the good side of the company. Like when you're getting into a marriage or getting into a relationship, initially parties show only the good side of themselves. The only good side is shown to each other. Once you get into the relationship, once you get married, only you see the real picture, the obligations, the liabilities, the risk that you never saw. So before getting into this relationship, before getting into this merge or acquisition, you have to look at who the devil that you're going to enter into this arrangement, transaction, whether he's a saint or devil, actually, an agent or not. So for that, you should know what obligations that they have, debt obligations, how much they are supposed to settle, how much they have already paid. Have they defaulted on any of those amounts? Can you use the assets of the company to settle those liabilities at any point? If you have to make the employees redundant, these are operational due diligence. This is financial due diligence. And it couples with legal due diligence as well, because there is a possibility here, someone you have defaulted and the creditors may try to take action against you. Sometimes there can be ongoing litigation. So the due diligence must be done to identify those things. Debts, employees, because if you have to make them redundant, you have to pay them compensation. And there is a shareholder who has 20%, but he has not disclosed his interest in the preliminary discussion. And to do the acquisition, you have to borrow money from outsiders. So it's a huge risk that you take. If you become a failure, not only you will have to pay the liabilities of the newly acquired company, but the funds that you borrowed to acquire the company as well. So that is the whole purpose of doing a due diligence. And then even the land that you're acquiring has some regulatory restrictions. That means it is not completely free from encumbrances. That means you cannot freely utilize the asset in the way that you want. So for that purpose, you have to do this due diligence. Then evaluate the responsibilities and competing interests of management, shareholders, creditors, and employees. Now, this is a simple one. You know stakeholder analysis. You have done it for other subjects as well. What the shareholders from a company are different from what the creditors and employees want. So you know what the shareholders expect from a company. What is why the shareholders are interested in a company? Shareholders are interested in a company for dividend and, in simple terms, maximization of shareholder wealth. That is the interest for shareholders. Creditors, their ability to recover the principal amount of money that they have lent along with the interest relevant. Employees, job security, and to have the employment benefits such as salaries, bonuses, and other non-cash and cash benefits that they are entitled to. Mostly job security and ability to get their salaries. Management, the board of directors, the management, again, they look after, no, they're actually asking about only shareholders, creditors, and employees here. So those are the interests that they are having. Then analyze the legal consequences arising from the director's failure to disclose his interest in Innovis Analytics Private Limited and advise whether the director should continue participating in board deliberations relating to the acquisition. So I will simply explain it, but later the answers to these questions will be shared. So then you can go through it. But since I don't have enough time, I will quickly give the underlying answer here. So director's failure to disclose his interest is a breach of his fiduciary duties and governance. We learned earlier also, if you're interested in a transaction, you have a disclosure requirement. If you have failed to do that disclosure, then you are in breach of your duties of directors, and it is a reason for you to be removed as a director of company as well. And there are other compensation requirement also, compensation consequences as well, if you have failed to fulfill your requirements as a director. So that's a disclosure requirement. And then explain how digital tools and data analytics may be used to support planning, stakeholder communication, and post-merger intention. This is from digital analytics and digital platforms. So since it's part of the syllabus, these areas also can be included, though it's the law paper. So This will, as I mentioned earlier, uh, these will be helpful in basically now digital tools and data analytics may be used to support post-merger integration. So basically, uh, when you're going for an acquisition, a merge like this, time is essence. You don't have a lot of time. You need to deal with a lot of facts. You need a lot of statistics. So definitely to expedite the whole process and to come up with better analytic and better outcomes, better conclusions, these tools will be definitely useful. Because if you use these conservative traditional methods to analyze data, it will take a very long time period, and there is a higher possibility that you would make mistakes. But you can avoid all those things. You know that the AI tools and the other tools that are available, sometimes they are customized in such a way that to deal with finance, legal related matters. So when you use that kind of specialized AI tools to get whatever the reports that you require, and that will give you very useful information to make all the decisions that are required. So on a single go, at a single, on a single go, you will have all the reports that is required, and based on that, you can make whatever the decisions that you want. So I wish I had more time, but unfortunately, in the interest of brevity, I need to hand over this discussion to my colleague to continue with the discussion for the tax part. So what I will do is I will share the answers to these questions with the admin. So they will do the needful afterwards. Okay, right. So thank you very much. I really uh, appreciate the opportunity that was given to me to have this discussion. So, with that, I will conclude my session and I wish you all the very best. May all of you get through your papers. Thank you very much. I will hand over to my colleague to continue with his discussion. Thank you very much.
Hi, Ravindra sir. Mr. Arun, can can you hear me?
Yes, we can hear you. Obviously. Yes.
Right, all good. Uh, Let me share my screen. Wait. Right. Hope I'm audible enough and my screen also visible, right?
Yes, we can hear. We can hear.
Perfect. Yeah. Welcome all of you. I think you already discussed the low part, corporate low part. Rakita sir explain you. I'll go through with the part one, corporate low part. So I'm going to discuss corporate taxation, framework, compliance, and dispute resolution that will carry altogether 45 marks out of 100. So you will get this recording. Right. Sorry for that. Right. 45 marks out of 100. So out of 100. So this is important you to understand the how many how many minutes allocated to this tax paper because it's contain section A and section B. Then the section A will have two short scenario questions and the one extended complex scenario question, that is corporate taxation part. So each question, this part you will have 10 each, right? 20. And this one you will get 25. Then altogether 45 marks. So when it's come to 100, then it's divided by 55 marks for corporate law and the 45 marks for the tax. Then if we allocate, let's say, how about the mark, the time allocation for each, this 55 multiplied by 1.8, you will have 99 minutes roughly, right? So, and when it's come to this one, if you multiplied 45 into 1.8, and you will get 81, right? Altogether, you will get 99 plus 81, 180. That is 3 hours, right? If you divide it by 60, then 3 hours. So you need to try to manage time, that is minutes, 81 minutes, 1 hour and 21 minutes roughly. So 1 hour and 20 minutes. You need to manage your time properly, otherwise you will end up with uh, difficulty to answer all the questions. So because tax, when it comes to tax paper, tax part, it has 3 questions. So all the questions are compulsory. And in the open books, when it's come to open books references, Inland Revenue Act with the subsequent amendments. So if you are required, you can bring your Inland Revenue Act with the, you can put the note reference which are important if you feel like to refer at the exam. Then I will tell you which section better you can put the bookmarks So then and there you can refer. So Value-Added Tax Act and the subsequent amendments. So both you can carry to the exam as open book references. So, and you need to mindful, not like lengthy notes, those things are not allowed at the exam, right? So let's jump into the second part of the paper, corporate taxation. Right. In the part 2, we are going to discuss 10-mark section first, that is value-added tax, right? Then as I discussed earlier, that is altogether 45 marks. Then here it's up to you to decide which question you are going to answer. Either if you prefer, you can go to the 25 marks one, like to score more in the beginning, and then jump into 10 marks. It's up to you totally. But if you're comfortable with getting 20 marks first and then jump into the adjustments with the corporate taxation, it's personal choice. And then for this discussion, I will go through with the order, like the first question, the value added tax, right? So the question 6, when it's come to the question, better if you can read first the requirement. So then you know the big picture, what it is about. Then with this understanding, you can go to the scenario to read first. Then the requirement, I recommend you to go through with the requirement first. And what is the requirement in this question? It's asking you with the action verb, calculate the balance VAT payable or refund due Ceylon Tech Private Limited for the quarter ended. See, very important, you need to understand the quarter ended 31st March 2026. Clearly show the VAT treatment for the each revenue and input VAT item. Then you need to clearly show the VAT treatment. Then it's contain altogether 6 marks, right? Let's jump into the question first. CT Private Limited is a VAT registered company in Sri Lanka, right? Then definitely in order to pay VAT, they need to register, right? And then engage in the manufacturing and distribution of smart home electronic devices. The company supplies its hardware locally and export extensively to the Middle East. So locally, they do local as well as export. Then you should be able to understand, then it's a clue that they have local sales. They are selling within Sri Lanka. So, and also they export. Then definitely export. Uh, what is the tax rate for export? The VAT rate. You can use chat option. You can provide answers then and there while we are discussing, right? To Middle East. Right. Perfect. That is 0, right? Then in addition to its manufacturing operation, CT operate registered education institution providing a specialized certificate of robotics and IT. So when it's come to education in VAT law, what do you feel? Then definitely this have what? Any answer? Yeah, very good. That is exempt. Exempt. Then this is export 0%. Then the local sale as per the VAT law, what is the percentage? Who can tell? Yeah, perfect. That is 18%. Very good. Yeah. And then we know that that's big picture while reading the first para, right? Then finance manager is preparing the VAT return for the quarter ended 31st March 2026, has extracted following data, all values. Here is another important thing, right? Then the quarter is important. What are the things which are very important you to highlight at the exam? I also encourage you to highlight at the exam hall as well, right? Then you never miss anything, right? Always you follow the things which I am highlighting and do the same thing at the exam. You won't miss anything, you won't lose any marks, right? So all value exclusive of VAT. Exclusive of VAT means, is it 100 or 118? Exclusive of VAT in the sense 100 or 118. Very good. Yeah, it's 100. So exclusive of VAT in the sense it is 100, right? So, right, not the 118. So if the examiner says it's inclusive of VAT, the following figures are inclusive of VAT, then 118. Then here it says clearly exclusive of VAT. Then if we wanted to calculate the VAT, we need to multiply it by 18%, right? It's clear. The revenue streams description, then the local sales, they have local sales and the exports, right? Then value, no need to read at the exam. You can save time. You can quickly read the items, right? So then the course fees collected. Then as you know, now this is 18% and this is export, 0%. And education institute, this is exempt, right? It's clear. Then we are getting these marks right now. Then we'll quickly read the entire questions and then jump on to the answer. So then next page, if you jump into here, input VAT incurred during the quarter. Here, very important. In the exam also, you need to read properly input VAT. Here also it says very importantly, VAT paid, not the value, right? Is this 100 or 18? Is this 100 or 18? Yes, perfect. It is 18, not the 100, right? Then we need to be mindful. So when we are doing the question, and very importantly, you need to take this exact figure without doing any multiplication, because we notice sometimes students, they multiply this figure, right? And take again the 18 on this amount. Then they end up with losing marks. So, and then very importantly, you need to mindful, this figure is what, right? It says clearly it's VAT paid, right? VAT paid on electron component directly for smart home devices, right? Which is used. Then the VAT paid on this one. Can we claim this one or not? Can we claim this one or not? Can or can't? Yes, exactly. We can claim that one. So the next one, VAT paid on a new commercial delivery lorry. Commercial delivery lorry. Commercial delivery lorry. Used for local distribution. Local is VATable, right? VAT liable. We discussed that. Then the local sales, it's 18%. Then can we claim this 1,500? Can we claim that one? Yes or no? Yeah, perfect. We can claim that one as well. Then VAT paid on computer purchase exclusively educational institution, right? VAT paid computer purchase. Can we claim this one or can't? Yes or no? Education institute. Education, is it VAT liable or exempt? Education, we discussed short while ago. Cost we collected education, VAT exempt. Then we can claim here, yes. Here also, yes. Here, you cannot claim input because it belongs to education institute. Our taxable supply and non-taxable supply, exempt supply. Then it belongs to exempt supply. Then we can't claim VAT, right? Then VAT paid on common overhead expenses. VAT paid on common overhead expenses. Then the electricity, office rent, audit fees. Can we claim this one? Yes or no? Yes or no? Yeah, that is answer is correct. Can we claim, if I ask like this question, can we claim 100% entire 2000 or not? Perfect. Yeah, some answers. Yeah, we can't claim entire 2000, right? So we can't claim entire. Why? Because we have mixed supply. If the company having taxable supply and exempt supply, we need to prorate or apportion between taxable supply and non-taxable supply. Then we need to proportionately allocate that input, right? So that is very important, right? So we'll take the next one here, right? Perfect. That we can claim, yes, but as a percentage only, right? As a percentage only. We need to determine how we are going to proportion it, right? Oh, good. Then let's discuss additional information. CT has valid tax invoices and export custom declaration, right? They have valid tax invoice, very important, and custom declaration. We call it as CUSDEC, right? Custom declaration, CUSDEC. In general term, we call it as CUSDEC, custom declarations for all relevant transactions. Then, in this sense, we can clearly determine, we can claim all the inputs which are eligible, right? Then, because company has all the valid tax invoices or CUSDECs, right? CUSDEC also treated as in VAT law as a valid tax invoice. So we can claim. Then if in the exam, if you got something like company does not have valid tax invoice for only for 500 worth of something, right? Then you need to remove that part. So in this scenario, we don't have such case. So therefore, in this calculation, we can claim entirely because thing has telling that we can claim entire, they have valid tax invoice. So then the unabsorbed input VAT brought forward from the previous quarter. It says unabsorbed input VAT. Then brought forward amount from previous quarter, that is 31st December 2025 was 400,000. This is important when we are doing the calculation part. Then I will jump onto the calculation very soon, right? This is done, and then the next one, to host its international databases, CT plans to subscribe to a cloud-based hosting services provided by the CloudNet LLC, a non-resident tech company with no physical presence. They don't have physical presence, right, in Sri Lanka, effective from 1st October 2026. CloudNet supplies its digital services through an electronic platform to multiple businesses and consumers across Sri Lanka. So they are providing digital services, right, through electronic platform. They are having the company, they operate as a non-resident, they are doing their head office somewhere else. They do provide services outside Sri Lanka. So this part, we can assume that which is not connected directly here, because they are going to do, it's connected to, I couldn't read the last part. This is connected to the description. See, if you look at the CloudNet LLC, it says analyze the VAT liability and registration requirement applicable to CloudNet LLC for the supply of digital services to Sri Lankan users. Your answer must cover the relevant statutory chargeability registration threshold, chargeability registration threshold, and compliance mechanism introduced under the Value Added Tax Act amendment as amended, right? So this part we'll do later. Then we'll jump on to the third part when we are doing this part 2, part B. Then we'll quickly do the calculation. For my easy reference, quickly I just came up with the sample answers. We can quickly jump on and finish it off. So then smart local purchase, local sales. If we go here, local sales, we have 40,000. So in the exam, I encourage you to have the same type of format. Better you can do that way. So you can quickly do your answers. So then 40,000 into, as we discussed already, 18%. So 7,200. So exports. Export, if you jump into export, 20,000 into 0 rate. So if you wish, you can have the percentage to show in the exam, right? Applicable rate if you want, right? Then that way you are showing to the examiner that the applicable rate, it's easy. So this 18%, right? And here 0. Then 20,000 multiplied by 0%, that is 0, right? Then this one, course fees, education institute, we know that it is 15,000, it is exempt. No need to even multiplied by 0, not 0. Then if you analyze this question, right? So you can see, if I drag this one a little bit, right? So this part, this is liable, right? Liable at 18%, right? This is also liable, but 0. Because to encourage exporters, because if you export something from Sri Lanka to other country, then we need to compete with the global competitors. That's why we have VAT rate 0, right? This is not liable, right? So that's why we need to consider these two when claiming the inputs, right? So then in order to claim inputs, here can claim, here also can claim inputs, here also can claim, here you cannot claim because it's exempt, not liable. In simply if I say exempt, right? So cannot claim here. Cannot claim inputs. That is the difference, right? Then we'll jump on to the next input tax paid, right? Here, VAT paid on electronic components 3,500 because it says VAT paid. So that is the marks allocation also given to you. Then you can see how the mark allocation goes. So actually, I need to total this to 3. Then you will get 7,200 here. And the total supply would be 75,000. Then how much would be the taxable supply? Can someone tell me? You can use the chat option. How much is the taxable supply? This is the total supply. Perfect. Yeah. Taxable supply total is 60,000, right? 60,000 is the taxable supply. Here, taxable supply. This is we need later, right? How much is the taxable supply? Then the total supply is this much, but taxable supply is 60,000, right? Then, right. Then here, how much was the amount? That is 3,500. You can deduct these things. So I would say less input VAT claimable. So input VAT 3,500, right? So then we have paid on delivery lorry 1,500, and then education institute. Can we claim or can't? Education institute, we cannot, right? So we cannot claim that one. So because it's belongs to XM supply, because it's connected to XM sale. Any purchase, if you paid VAT, which are belongs to, if the examiner directly tell that this particular purchase is belongs to XM supply, you can't claim, cannot claim. So if you want in the exam, cannot claim since it connect to XM supply, right? If you want, you can write that way, but not necessary. You can take as 0. It's implied you know that one, right? Then what happens to the last one? 2,000. Common overhead expenses. That is 2,000. So common overhead expenses, input VAT paid on common overhead 2,000. Then how much belongs to taxable? Then what you need to do is, then if you divide it by 75,000 and multiplied by 60,000 taxable supply, then you will get exact amount, right? Then 2,000 is the total amount. If you divide this one by 75 and multiplied by 60, you will get exact amount, which is allowable input tax, right? Belongs to taxable supply, right? Then in the exam, question was telling that the last as the note, additional information number 2, 400,000 was the input tax brought forward amount, right, from the previous quarter. That is 400. Then we can take. Then total input tax would be How much? Claimable input tax total 7,000, right? 7,000. Then the balance VAT payable for the quarter would be this one minus this 200, right? Hope this part is clear, right? You can put yes or no. Clear? The question 6, part A. Yes or no? This is easy one, right? Right, perfect. So it's done. And then when it's come to the second part of the question, right? Second part, the analyze. Yeah, sorry, answer this one. Yeah, you can take a snapshot, but the See Sri Lanka will email you this one. I will share this Excel sheet, then you will get the same copy, right? And when it's come to the part 2, right? Analyze VAT liability and registration requirement applicable to CloudNet LLC for the supply of digital services. Yeah, I'll try to attach this one. Let's see. Right. So analyze VAT liability and registration requirement applicable to this one is calculated 1600 because this is the formula. You can see because total was 2000 because it is common overhead VAT. Then in simply අච්චරට මෙච්චර නම් එච්චරට කොච්චරද, right? The apportionment total supply you divided by total and multiplied by the liable, right? Right. Because we can claim only inputs tax belongs to liable. We can't claim exempt inputs. Like we remove this one because we can't claim because it says in the exam, it says clearly it's not belongs to liable supply. It is exempt. We can't claim. But there are some common purchases because like electricity, overhead, telephone, all this, they can't determine exactly how much belongs to exempt. Then we need to proportion it, the portion according to the turnover. Or in the exam, sometime you will get percentage. 20% belong to exempt. Then only you can claim 80%. Right? That is clear, right? So then the VAT liability. Here again, I'm highlighting the analyze, asking you to analyze VAT liability and registration. VAT liability and registration requirement applicables to this company. Non-resident, right? This is non-resident for the supply of digital services to Sri Lankan users. Your answer must cover the relevant statutory chargeability, right? Registration threshold and compliance mechanism introduced on the recent VAT amendments, right? Then 4 marks. So under this, if you look at the scenario given, then they are going to subscribe cloud-based hosting services provided by CloudNet LLC, non-resident tech company, which is not having physically presence in Sri Lanka. They are doing because they recently enacted this one and now they are going to postpone. They postponed till the enactment. Earlier it came into effect with the amendment 1st October 2025. Now, recently they postponed it to 1st July 2026 onward, it's effective, right? Then that legal enactment to be received, right? This one is important. Most of the companies, like international companies, they are taking Sri Lankan money, right? They are providing hosting services, cloud-based, these type of services, and there may be Microsoft, like the foreign exchange, cryptocurrency, all these services. If they are doing services without coming to Sri Lanka and they are earning from Sri Lanka while being outside, right? So non-resident, then they need to register now for VAT, right? Now, if they are getting income from Sri Lanka, then if they exceed the relevant threshold, how much the threshold for VAT purpose? In order to pay VAT, what is the registration threshold? Yeah, yes, yeah, exactly. Yeah, yeah. In order to register, they need to meet per quarter 15 million per taxable period or 60 million 12 month. So in order to register, because if you have like as a company, then they are not required to pay VAT because they start from the zero, right? Then when they are growing the company, then there is a threshold, right? If you exceed that below threshold, even Sri Lankan company, this is the red line. If you cross the line, this is called VAT registration threshold, right? Registration threshold. This is per quarter. This one per quarter 15 million. This is per quarter. Then per annum 60 million. Quarter multiplied by 4, right? Per annum. Right? If you exceed this amount, they need to register, right? If they exceed, then here the point where they are exceeding that amount, right? They need to register for VAT, right? Then even if they are going to decrease the registration threshold or sometime if they are getting low income until they officially, even if they go down, right? Again higher and again down and again getting more, right? Then no need to deregister here. Since they have still valid registration, they need to collect VAT and pay to the Inland Revenue Department unless if they have officially deregistered, even below the threshold, right? Once they registered. This is additional information for you, right? So for the question, yeah, 15 million is the per quarter registration threshold, per annum 60 million. So then what happened? Once they registered, they must charge. So soon after they registered, then maybe they are supplying to a registered person or not. That doesn't matter. They will include when they are making as a company. Then let's say CloudNet, if they registered for VAT, right? If they registered, when they are issuing invoices, right? Sales. So they need to charge VAT with the 100, then charge VAT and 180. Then if they are issuing invoice to VAT registered person again, they will issue a tax invoice, right? If they are making sales to non-VAT registered person, here is a VAT registered, right? If they are issuing VAT invoice to non-VAT registered person, right? They will just say inclusive invoice 118. Because if you go for shopping mall, if you purchase some items, bag, clothes and everything, you don't get usually VAT invoice, right? Because you are just customer, individual. Then you will see only 118 because that shopping mall, right? They need to pay VAT on their sales since they are exceeding 15 million per quarter, right? That is 5 million per month, right? Then they need to collect VAT, right? In simply, if the answers, if I jump into answer sheet, right? So the statutory chargeability, because I drafted this one in order to save our time and discuss the questions more, right? So then that is imposed on digital services by a non-resident person in order to, because they are going to now expand the government revenue. They are bringing new laws with the IMF support, right? So influence, we are borrowing money and then we need to again increase the government revenue. So the another law they came up with the implementation that is going to effect from 1st July 2026 onward. Any foreign person, non-resident, if they are providing digital services like cloud-based, this is highly relevant these days. So maybe sometime you might get this one or not sure. So then they need to register as per the new law, right? They need to register. And even as we discussed, even though they are not having physically presence in Sri Lanka, right? They are maybe UK, US, Dubai, wherever, right? If they are providing services to Sri Lanka and earning money from Sri Lanka, then that is taxable activity. Then they need to register. When it's come to registration, as you said, 15 million per quarter. This LKR, not the dollars, right? Or 60 million 12 month, then they need to register. Then 1 mark for this and 1 and again 1. And once they registered, what they need to do, issue tax invoice and collect the VAT. They need to register as a non-resident person in Sri Lanka for VAT under the VAT law, get the TIN number and get the VAT registration certificate and pay the VAT to the government, collect through the invoice and pay to the Inland Revenue Department. All right. Hope it is clear. Right. Let's read this one, question 7. That is just the first part is the explaining about the non-resident chargeability. Non-resident, as per the new amendment, even if it is they are non-resident, right? They need to pay VAT if they are providing digital services, right? If they are providing digital services. Right? Right. Oh, good. Yeah, we'll jump on to the next question, question 7. Right? I encourage you to read the requirement first. Yeah, you will get the recording after the sessions, all right? And probably this session, you will get tomorrow probably. And this with the answer sheet, which we are discussing today, the Excel sheet. Email, you will get an email. Yeah. Right. I encourage you to read at the exam all the requirements and then focus first one when you are reading again with that mindset, because then you can feel okay, this is what they asked, this is the answer, right? So we can construct our answer in the mind, like while having the requirements, right? So the requirements, so analyze the specific tax consequences under the Inland Revenue Act of the unpaid balance being treated as tax in default. Right. Tax in default. Right. You need to analyze the tax consequences on unpaid balance tax, which is tax in default. Default in the sense you haven't paid yet, right? Default. You are a defaulter. You didn't pay. It's a liable, but you haven't paid that one, right? It's called tax in default, right? In tax terms, right? You didn't pay, right? And they again recommend 3 practical steps OF, Ocean Pressed, should take to manage and mitigate this default situation after receiving this notice, because they receive a notice, right? We will read the very shortly what other story about, right? What is the story? So then take then the practical steps should take to manage and mitigate default situation. And then finally assess 2 specific statutory recovery actions, right? That IRD may legally enforce against the company. Then as a recovery action, the keyword is recovery action. Right? If you have the Inland Revenue Act, you can see, because these things you can bookmark, right? Recovery action. Then actually I forgot to tell you, in the even the VAT law, what are the exempts list. Then the education, yes, you know this, that is exempt. That export, you know, anyway by default, it's anyway everywhere, every time you learn, right? So, but same list, if you can in short, you can write in that itself where the exam list, then you can highlight and put a bookmark, right? Sticky note or something, where you can quickly refer. Okay, is this an exam? Oh, I'm out, right? You just quickly turn into that page, exam list, and then identify and make sure that is okay, that is exam, right? Then the exam, then when it's come to apportionment, then the how to apportion, then its law says, then you can somewhere, you can have a small example like this. A divided by b. Likewise, you can't put all the jargon there, but you can simply say this is where you have to proportion it, the common supplies, right? Common inputs. Yeah. And that exempt schedule is there, right? The same way, if you look at recovery actions, then if it is tax in default, where the penalty, right? And then you can bookmark there, like the put is sticky note, recovery action, what are the legal against the company if they fail to settle tax in default, right? If they fail to settle tax in default, right, then they can IRD what they will do, right? Let's read the scenario first. Ocean First Private Limited, OF, let's say OF, right, is a Sri Lankan company engaged in processing and exporting seafood products. The company, right, file its corporate income tax return for the year of assessment 24-25, right? Because I just highlighted because it's important, right? Corporate income tax. Anyway, this question is belong to income tax, right? Administration, right? Corporate income tax return. This is for the year of assessment. Then if you take year of assessment 24, 25, right? Year of assessment 24, 25. Then the major other than quarterly payment, I'm not talking about the quarterly payment here. Then the return is due on when? For this quarter, for this year of assessment, the income tax return is due on when? Can someone tell me? When the income tax return due? Tax due on when? Alright? These are important. But in the question, talking about the final payment, right? Yeah. Yeah, I got now right answer. That is 30th November 2025. 2025. Then when is the final payment deadline? Final payment. Somewhere here. Final payment. If there are any balance tax payable for this year, right? When you made quarterly payment and then after the audit, and then you will have audited financial statement if there are any balance tax payable. Like you paid quarterly 25, 25, 2500, but your final computation when you did, like you paid quarterly 100, 25 into 4, right? 100. Then your actual tax liability was 120. Then there is a 20 payable. Then this 20 you need to pay on or before when? On or before? Yes, perfect. 30th September 2025. 30th September 2025. All right. Yeah. Then with that understanding, then that's good you have that understanding. So, and declared final balance income tax payable as 8 million, right? Final tax payable was 8 million due to temporary cash flow difficulties. Only 5 million was paid on the statutory due date, that is 30th. The statutory due date is 30th September 2025, right? They paid 5 million out of 8. Then there is a 3 million default. They didn't pay, right? They didn't pay this 3 million. So then company has now received a formal default notice. You are a defaulter, right? From the Inland Revenue Department stating that the unpaid balance of 3 million is treated as tax in default, right? Then the 3 million you were required to pay 5 million as per the calculation, right? Yeah, here if I take that example, then 108 was the amount they paid 100, and then 100 and let's say 5, then 3 million was default. Yeah, we'll take exact amount 8 and 5 million they paid, and the 3 million was default, right? Right. And notice also refer to the imposition of penalties, interest, and potential recovery actions. Then it says penalty. Then the question itself, you can get a clue to answers, right? It says penalty, interest, and recovery actions, right? If the amount remain unpaid. So, right? Finite direction, accept that the tax balance is payable, but is concerned that making an immediate full payment will severely disrupt the company's working capital and export operation. So the finance director aware this issue, right? But the thing is they can't make the payment because of current financial hardship, right? They are having the working capital issue, right? Assume you are the senior tax advisor of Ocean Price, right? So with that, then we know what has happened. There was a payable. The total tax payable was 8 million, but they paid only 5 million, and there's 3 million default. And then with that understanding, we'll jump on to analyze tax consequences, right? Being default, right? What will happen if you are a defaulter, right? Just assume if you are not paying tax, right? IRD will impose what? Especially when it's come to final payment. They will impose what? Any answer? They will impose? Exactly. Then consequence is penalty. And not only penalty, then what else? As per the new Inland Revenue Act, you will get penalty. What is the penalty percent rate? Yeah, perfect. Anyone else? Yeah. Interest percentage is wrong. Yeah, penalty is correct. I'm talking about someone answering, right? So penalty and interest, right? Now, then you can bookmark these things in the Inland Revenue Act. It specifically says in the act how much is the penalty rate, how much is the interest, right? If you go to Inland Revenue Act section 179, right, it says 20%, right? Penalty is 20, right? And when it's come to, right, interest, it is 1.5%, right? Compounding monthly. So when it's come to here, right? So first one, you will get 1 mark saying that the penalty 20%, right? So again, you are required to say 1.5% per month interest compounded monthly until they settle, right? So if they fail to comply within 21 days after the notice, then they will get the recovery action, right? Recovery action, right? This is the first part, right? Recovery action, they will take recovery action. This third part B of the equation 7, then the recommend 3 practical steps Ocean First Private Limited should take to manage and mitigate this default situation. So what are these steps? So they can take, let's discuss first. What are the steps they can do, right? Then once you receive the default notice as a senior tax consultant, right? Right. Yeah, in the answers, if you can mention the relevant section, that would be great, but it's not the requirement in this level, right? But if you can give the exact section, that would be great because it's open book. You should be able to search even if you download the Inland Revenue Act, right? I prefer if you can download the consolidated one because I can't with this time and limit. I can't go through with the section in the act itself. So if you go to IRD Sri Lanka, right? So here, I encourage, if you are studying the act, because you can't bring the consolidated act to the exam, if I'm not mistaken. You can double check, right? Then you need to take the original act amendment separately. So there's a latest amendment as well. So, but if you click in your exam, you won't get any questions with this amendment, right? Because this is the latest one, which is not past 6 months, right? They have just certified 3rd June this month. Then, because once the speaker certified, it should be in practice at least 6 months to test in the exam, right? So then you won't get this one, but till this, but you are lucky, then you have consolidated version. If you in the Inland Revenue Act, if you open the consolidated version, then you search it, then the control F, right? That's it. Go each sections, you have all the sections here as a summary with the hyperlink. Then the main deduction, repair and improvements, when we are discussing, then you can jump on all the sections very quickly. No, I don't think photocopy is allowed, right? Maybe it says clearly in the open book you have to purchase, I think, right? So the near to AT building, that is then the government printing department, you can get this act. Earlier the Inland Revenue Department itself, you can, there are some acts they are selling from them. They are building as well in the Revenue Department. I'm not sure that currently they are doing. You need to go to government printing department. Maybe, and also you can get it from the Sri Lanka, if I'm not mistaken, the publication unit or the open book reference. You can't take the printouts. Right? So all the sections there, right? You can go one by one. Then you can bookmark each sections. Then you can refer, right? Then default payment, right? Section 52. Then interest rates. Then the section 59. So if you look at then that we discuss 1.5% per month compounded monthly. So those things I'm not going to go through with the act and highlight with that, because once you listen this recording you will see, and with the answers I have mentioned the relevant section as well. You can highlight and be familiar with that, the relevant section, because you don't need to read in all act, and just highlight the things when you are learning, right? The relevant sections only, then bookmark them, right? Oh, good. Then let's jump on to, right. Let's discuss this second part, right? The part B of the steps, right? Then what are the action recommended 3 steps you can take, right? As the tax consultant, right? So first, what you have to do is, if you receive the default notice, that is 3 million, then what you will do first? Can you tell me, someone? Just use the chat option, that's fine. Then if you receive, then you notice that the earlier answer that penalty is 20%, right? And the interest 1.5. Then you need to quantify that one. Then the how much would be the penalty? The penalty is 20% and the interest is 1.5. Then if you not paid from this date onward, right? So what will happen? So then till this we can roughly quantify, right? In the exam no need to do the calculation, penalty and interest calculation, but you just need to mention we need to first calculate the or quantify the penalty and interest exposure would be how much, right? Because due date was 30th September, right? Due date is the 30th September. Then if you didn't pay that one 30th September, then you will get 20% penalty and 1.5% interest per month, right? Until you settle. The penalty 20% is fixed, right? And then interest continuously calculate. Then in the exam, you don't need to calculate the penalty and interest, and then you just justify the answer, the applicable penalty and interest. You need to, as a accountant, you need to roughly calculate how much would be the penalty and interest, right? And then the secondly, what you need to do, right? You can, if you get like this default notice, you can get a time extension or permission to settle outstanding 3 million tax liability with accrued interest and penalty, right? You can get an extension by asking. You can submit a letter of objection saying that, and then with the request asking to get some extra time, and then justify the reason why you are need extra time. Then maybe you need to discuss because of the financial hardship, and you can provide some supporting evidence. You don't have sales, bank statement, budget calculations, right? As a justification. So as a recommended options, you can suggest that calculate the, right, the part B, then the quantify the total exposure. You can calculate the 20% tax penalty and 1.5% monthly interest to the board, and then you can formally write a letter to Commissioner General requesting extension, right? Extension or permission, right? With the installment plan. Right. Then maybe you are required to submit with the reason why you need extension, right? So with the supporting documents, right? Maybe budgeted, forecasted budget, right? And then bank statement. Then you don't have, by showing them you don't have capacity to, you have a working capital issue. So then they will, if they believe that one, then they will give some installment plan, right? Then let's look at the part C. Then the part C, assess two specific recovery action, right? That IRD may legally enforce against the company if it failed to settle the tax liability, right? Here I will tell you, like, if you not paid taxes, right, then what are the action in the department can take? So, right, then they will impose penalty and interest, we discussed already. Then finally, they are going to take recovery action, right? What are the recovery action, right? Then assume that in the, like, think like practical scenario, like if you obtain a loan from a friend or someone, like if you apply this type of scenario in your day-to-day life, you will get the answer same like in the VAT law or tax law, indirect vector, right? If you apply this one, right, if you obtain a loan from a neighbor, right, then you didn't pay that one as agreed date, then they will inform to, if you are not settling the first, they will inform to you, and if you are not settling, they will inform to your parents or any other party you are getting money, right? So same way, then Inland Revenue Department, they will go to third party, right? If someone like maybe bank, right, they will issue a third party debtor notice to a maybe related party company, or maybe like the customer, main supplier, right, main customer. Then they will issue a letter to saying that this Ocean First is not settling that the amount is owing to the tax. The tax in default amount is 3 million. If you are going to make the payments to Ocean First, then no need to settle that amount to OF, directly settle to the Inland Revenue Department. They have that power, right? And let's say Ocean selling some goods to the customer, then the customer having the balance, they are settling maybe 30 days. Then IRD will go to the customer and don't pay to Ocean and pay directly to the Inland Revenue Department. They have that power. They can enact that one by issuing a notice to third-party debtors or bank. They can seize bank otherwise. Then if they have a bank account, then the Inland Revenue Department, they can seize. They can't operate that bank until they settle the liability, right? They have that power, right? You simply write those things, right? Or otherwise, they can seize their assets. The land or motor vehicle belongs to motor lorry, right? Any assets belongs to company, delivery lorry or anything. If it is belong to company, they can take those, right? Then those things you can write to the answer, right? So if we go to the answer sheet, right, then as we discussed, they can write to bank, seize the bank account or issue a customer's letter saying that asking to settle directly to the Inland Revenue Department without settling the debts, right? And then they can take assets belongs to company, right? Then, right, hope this is clear, right? This is the tax administration question that is belongs altogether 10 marks, right? 10 marks. Then we discuss the question 6 and 7. Hope these two clear, right? Any questions? If you have, you can put into the chat. Yeah, you will get the answers definitely. Yeah, if I will try to share this in the chat, but you will get the recording and calculation sheet by tomorrow probably, right? Right. Then this is we are coming to the section B. Then the main, again, the big one, the 25 marks. And again, I encourage you to take, if you are attending to this one, you know this mark, how much is, right? So then the 25 mark multiplied by 1.8 always. So 25 multiplied by 1.8, how much? Then you need to finish this question within how many minutes? 45, right? 45 minutes. Then if you stay in this question, if you are started like this one first, right? You keep your like the watch, right? count that time when you are going to start. But if someone wanted to read the whole paper within 15 minutes, because you get 15 minutes extra to read and plan, right? You can quickly see the requirements and go all the questions, company law and corporate taxation, right? And then you can spare, like if you glance 5 minutes to whole paper and 10 minutes if you use for this, because this is lengthy one, like you will have like 2 to 3 page, right? Altogether 4 pages, right? So then you can spend some time because you get 15 minutes extra. So you spend 5 minutes to glance through whole paper with the requirement. Don't read the whole lot of things. Maybe quickly read the requirement, each question like this requirement only. Then jump into here. Okay, required. This is what, right? And then likewise, if you really want, you can go through it. It's up to you. It's your passion, right? Then otherwise, if I encourage you to go, then balance 10 minutes, right? Then you spare that time to here, then you can finish this one, not 30, 45, because this is long question. Then you read the requirement quickly here, and then start reading the question because it's long, right? Then what you can do is, at least if you 10 minutes you can save, then 35 minutes, within 35 minutes if you finish this question, right, you have big amounts to attend other questions, and then jump into the corporate law, right, if you attend into tax first, right. Then question 8, I encourage you to read the requirement first, then the calculate balance tax payable or refund due for Ecotech Forever Limited for the reimbursement 25-26, right? Balance tax payable or refund due, right? Then you are required to, right, clearly show the tax treatment for all item 1 to 20, indicating nil or 0. No adjustment is required. Because in the exam, yes, we know you are well aware about the adjustments and those are not required sometime. And then, right, if it is no adjustment is required, better to mention no adjustment, like we did in the VAT calculation, like we put 0, right? If you know that one, right, this is a 0 rated. If you delete that one, will you get mark? Without showing that one, will you get mark? And if it is exam, you know it is exam, you didn't show that one, will you get mark or not? Can you yes or no in the chat? No one there? Yes. You won't get marks. You need to show your knowledge, right? You need to show your knowledge, you know that one. Then only you will get mark. The same way, when it's come to income tax calculations, right, you need to show your knowledge. If it is no adjustments required, you just mention it is not applicable or fully allowed, right? Right. Then when it's come to the part B of the last question, so that is belongs to separate, right? Not belongs to like Ecotech is planning to do something and evaluate the tax liability. I won't read this part. And then tax deductibility of 15 million expenditure under the both proposals in strict accordance with this definition of research and development expenses under the IRA. And the third one, then this one is evaluation separate part. It's not connected with the main question, right? Then the third one, the part C, is gain on disposal of shares. Part A, state specific tax return that Ecotech is required to file and outline the statutory due date for both filing this return and making the respective tax payment to the Inland Revenue Department. Right? So then this one also not part and parcel of the calculation, but you need to mention the due dates. So I will read it again later, but I roughly read just before jumping into the question, right? So first one we'll do it leisurely because it's both a separate thing, right? We can attend later. Then it come to question 8. Let's read from the beginning. ETL is a resident company, right? In Sri Lanka, incorporated 2015, operate large scale manufacture of eco-friendly packaging material. In addition to the local manufacturing, company has successfully expanded into the global market by providing specialized digital packing, designing and IT consulting services to international clients. Global market, international clients. Then it says what? Like in the VAT question, it says what? They will have which revenue, right? Local sales and foreign sales. Perfect, right? Foreign sales, right? Then CFO is currently finalizing the corporate income tax computation for the year of assessment 25-26 and require for your expertise as a senior tax consultant, right? To prepare the final tax liability. Prepare the final tax liability and advise specific tax principles and propose investments, right? Financial information as of the company's draft P&L, the year ended 31st March 2026 as follows. Then they have given revenue, there's a separate note, and cost of sales, GP, other operating, no need to read numbers, you can save the time. And then operating expenses, finance cost, profit before tax, right? So then it shows the note number. We need to go through with note numbers, right? So note 1 in the additional information, revenue, as we noticed earlier, the revenue comprise 2 billion from the local manufacturing sales and the 800 million earned. This is local. Then the 800 belongs to foreign digital services provided to client base in UK, right? That is export. The payment for the export services was received foreign currency and remitted to a bank, like licensed commercial bank. So then this part, the revenue, right? Revenue 2,800 has two part. 800 belongs to export sale. Then the other one, 2,000 fall under local sale, right? Then what is the income tax rate for these two? What are the rates? For export, what is the rate? For export? No, not like VAT, right? Then income tax law is a different thing, right? Because we need to identify in taxation, VAT Act is a different one. Inland Revenue Act is a different one. So income tax is Inland Revenue Act, governed by the Inland Revenue Act. Then if you are asking in the exam, calculate the income tax payable. Then in the VAT question, if you clearly look at, calculate the VAT payable, right? If it is VAT payable, you need to go to VAT Act. Then the export 0. Then when it's come to Inland Revenue Act, export, that is concessionary rate, 15%. Normal, what is the rate? Local sale. Exactly. Yeah, very good. That is 30%. Right? Then that part clear. We know that one. Then at least if you couldn't go to the last application, at least you can mention the rate, right? You will get some part of the marks, right? So then, right. Then other operating income. Then this part, which is not applicable right now, you can remember, you can put a R, right? Then you need to come back again because there is a adjustment. You put some remember or remind mark, right? So I usually put R if I wanted to come back again, then see this one, okay, whether I'm going to adjust this one before finishing the question, right? So then we'll come back to this because no adjustment is due, right? Then when it comes to other operating income, then the other income consists of following, right? Other income, because you know that note number 2, other operating income 120,000. 120 consists of following. Then the interest income, exchange gain, and the gain on disposal of shares. 3 things. Then you know this is a separate source under the Inland Revenue Act. So sources of income. Income sources. If we take income sources, what are the sources we have? Income sources. If we take as per the Inland Revenue Act, what are the sources? Yes, business, right? Business income, investment income, other, BIO, right? If it is individual, employment income is there, but here in the company perspective, we have business. Then these interest incomes, right? Interest income won't fall under part of business, right? So it is fall under interest. Then it says gross interest, right? Gross. Then from FDs. Then realize exchange gain on export sales. Then the export sales realize exchange gain. Then this is, then sorry, I couldn't ask this one. Interest will fall under business or investment. BOI, you can mention in the chat. Interest will fall under BOI. B in the sense business, right? Interest in the sense investment. Sorry, I in the sense investment, right? Yeah. Interest fall under I, investment income, right? I in the sense investment. Business income, right? Then when it's come to gain on realization of, exchange gains on exports, it will fall under which category? Business or investment? BOI. Second one, sorry, this one, third one, Roman 3. Business or? Yes, perfect. It is connected to export sale. That's why I highlighted here, underline it. That is connected to business, right? This is passive income. Always passive income is investment. Passive means you don't do anything. You just put the money in the bank, you will get income. That is passive. Active in the sense you need to do something. Active. You need to do sales. Export sales. Then you will arrive. The active in the sense always business, right? Right. Then gain on disposal of shares. Say shares. Then this will fall under what? Investment or business. Right? Then the shares we just buy it and keep it. It is investment, right? You will get dividend as in income, right? And also you can get the gain if you are selling, right? That's it. You don't do manufacturing process or you don't do marketing, right? So just buy and sell, right? And that is called investment. So what we are going to do is we need to do first. I prefer you can follow the same format in the exam as well. So that way we can do the question while we are discussing, right? So first we need to take profit before tax. Always in the exam, you need to, if it is profit after tax, then here sometime you will get income tax and then profit after tax. Sorry, profit after tax. Then always you need to get profit before tax, right? You need to take the profit before tax and then do the adjustments because you are going to calculate the tax separately, right? That's why we are taking profit before tax. If it is the plus, if it is loss, you can put this column, and if it is gain, you can put here 430, sorry, 730. Right? Then you will have that one as a profit before tax. Then you will get one mark for that, right? Then this part, note 1, we will get back to this later. And then when it's come to this gross interest, interest is an investment. Then we are doing the business calculation, right? So first of all, we are going to calculate the assessable income from business. So then later we are going to calculate the assessable income from investment. So here, if you want, you can add before telling that the income tax computation, that is full broader term, like we say computation of income tax payable. Before that, you can say computation of assessable income from business, right? Like, because you first need to calculate the business. Right? So that part you are doing first, right? Business calculation, assessable income from business. Then anything not belongs to business, we have to remove, right? If it is interest, because it is belongs to investment, therefore we'll remove that one. How much? 20,000, right? 20,000. Then here I would say for this computation, I would say this is plus figures and here minus, right? Then gain on disposal of shares. Shares, it is investment, that is 90,000, right? So this one we discuss realized foreign exchange gain. It is form part of business, but it is included already. We don't need to do anything, right? Nothing to do, right? So no adjustments, right? You can mention no adjustment required. if I draw right, I'm just thinking about answers, right? Oh, good. Right. No adjustment. No adjustment required, right? One you can put zeros, right? And then let's jump into here. Note number 3. Then these 3 we have taken right now. So this one we adjusted, this one we adjusted, this one also adjusted, but I put R here. Why? Remember or remind me again, because there was a question belongs to this, right? I need to look at. Then because here I need to come back here to get the investment income calculation, this one, and also there was another part, this one also I will come back again to get under the investment. So these two I need to take it again under the investment income category, right? Investment income, I put I, because I need to come back again these two. Then I put remind R mark, so I will come back these two. Right. Then the operating expenses. Node number 3, 650,000. So that one, operating expenses, the operating expenses 650 include following specific items: accounting, depreciation and amortization. Accounting. Yeah. What you are going to do? So, what was the question? Yeah, fourth one we adjusted already. Disposal of shares. Then it should come maybe under here, no? Then it's clear. Exchange gain, no adjustment, right? Exchange gain, no adjustment. And fourth one, Roman 4, we adjusted, right? Clear? Clear, right? Right. Oh, good. Then accounting depreciation. When it's come to accounting depreciation, what we going to do? Accounting. Because tax purpose we claim what? Yeah. Capital allowance. Yeah, perfect. Then accounting depreciation, if you see this one, you need to add back because they have already deducted from the profit, accounting profit when they are calculating. Then we need to add back again and then claim capital allowance. So what I will do is then I will add back. So how much was it altogether? 85,000. In the exam, you need to mindful with thousands, right? Because zeros, if you put incorrectly, then your entire answer might go wrong, right? At least you will get marks. You can see how marks allocated, right? So if you put these at least roughly very quickly, if you are running out of time, at least put some figures and you will get marks, right? Adjustments. If you spend a lot of time for corporate law and then first and second question, then at least try to put some figures. You will get some marks. Here is actually you can get a lot of marks by doing small adjustments, right? So then I know that there is the capital allowance I have to do because questions I definitely know they should provide as a detail to do the capital allowance. Therefore, I'm not worried about here about capital allowance because they need to provide that information. Then I will get those information little later. Therefore, I will go through with the order, right? Then that accounting depreciation taken, accounting depreciation and amortization, and the penalty paid to the Inland Revenue Department. If you say penalty, then definitely what? Can we claim or not? Yes or no? If you see penalty. Yes or no? Yeah. If you see penalty, you can't, right? You can't claim because penalty, if you are doing the business right, why you are paying penalty, right? Then this is unnecessary expense. Accountant, they will deduct that from the P&L. But tax people, what we do, we don't encourage people to pay penalty, right? If you are doing the business right, it's not required to pay penalty, right? So any penalty like late payment, EPF contribution 500, and this one, right? 2,200 in 1000. So I will discourage this. So what you are going to do is you have to add back. Then penalty and interest 2,200 plus 500, right? Both, right? This include these things, then 2,200 plus 500 altogether 2,700, right? We are doing business calculation because I just was reading some questions, the student who are voting, right? So this we are just doing only business income calculation. Just business, non-related business things we remove. We will take later investment things, right? We will take investment gains later, right? Clear? Right. Then let's look at the next one, that is taken entertainment. Entertainment. Entertainment expenses incurred for a client. Client networking event 300. Entertainment for client networking. So if you notice entertainment, because in the act itself provide, if you are incurring any expenses, it should be directly connected to the production of income, right? Mainly connected with the production of the business, right? Under the general rule. If you are incurring any indirect expense, because someone can argue like entertainment, it's one mainly networking, and then we can get more clients and more business, then you would have categorized as marketing. Right? If it is entertainment, is entertainment. That is not directly, if you dance at the floor saying that entertainment, will it increase the production quantity? No, right? It won't increase the production quantity, but it will increase the networking and the PR company, right? Public representations, and then the networking and expand the client base, but it won't directly hit to the production, right? So if you notice entertainment, it's allowed or disallowed. Claim or no? Disallowed or allowed? Yeah, disallowed. That is how much? 3,000. Right. Then that's done. Then when it's come to provision for doubtful debts. Provision for doubtful debts, 5 million. And then if you notice provision, it's always we need to do what? Add back, right? The accountants, they will deduct whatever the provision made during the year. What we have to do is always add back. Then what we have to look at is actual written off. Written off is allowed, right? If they have taken recovery actions, right? Yeah, exactly, right? If they have taken recovery action, very important. If examiner says they haven't taken any recovery action, then you can't claim this 2000. So in the exam, in the question, if they say that clearly recovery action taken, then you can deduct this one, 2000, right? Then 2000 you can claim, write off, you can deduct. Why? Recovery action taken, right? Why? Recovery action taken. Right. Then when it's come to number 10, gratuity provisions, right? Perfect, very good, right? Gratuity provision, if you notice provision, right, is as I mentioned here as well, if you notice provision, always add back 12,000, right? 12,000. Then you can claim only gratuity payment, right? Payment made, gratuity paid, payment made 8,000, right? Payment made, you can deduct. I encourage you to follow the same format in the exam because it's easy, like plus minus, and then you just do the same way. Then you won't miss anything, right? Then research and development expenses. Yeah, 25 million, right? Perfect, very good. Even if the capital nature or not, entire 25 million, you can claim developing new biodegradable so polymer packaging internally. This company itself, they are doing the research and development 25%, 25 million, that is allowed, right? Then we can say allowed, 100% allowed, because already deducted, right? Already deducted, then no adjustments required. Again, earlier there was a additional 100% deduction rule was there under special deduction rule, right? Then that one no longer available, but whatever the amount, you can say allowed, right? Allowed. So no need to separately add back, give another deduction separately, right? Because it was amended to give in earlier 3 years. Now again they changed it to 5 years from the enactment because Act came up with 1819. Now 5 years gone. Then you can deduct whatever the research and payment. Now, whatever the things they have incurred, they can deduct, even if it is a capital nature or not, right? You can claim fully. Then number 11, marketing and advertising, 15 million, 4 million paid to a local printing institution for the development of printing point of sale POS material. So this is marketing, even it is 4 million, that is material. Then this is connected to the business. Without that, we can't do, right? Then that is allowed 100%. Then no adjustment required. So I would say no adjustment required. Then allowed. You can say allowed, right? Then when it's come to legal and professional fees, 8 million comprises 3 million paid to due diligence services, acquisition of new subsidiary. Acquisition of new subsidiary. It's a new company, right? The acquisition. Can they claim that one? 3 million. Right? This one. Legal fees out of 8 million, 3 million belongs to acquisition. It is capital nature. Then what you need to do is you need to add back 3 million, that is 3,000 in thousands, right? Then we need to add back that one because capital nature, right? It is not directly, it is still they are doing the groundwork, the acquisition part. Then it's not mainly connected with the business, no any production of income, right? Then donation, if you notice in the plus minus donation, what you do, allowed or disallowed. That doesn't matter approved charity or not. If you notice donation first, accountants, they will deduct. But what you have to do, if you notice donation, you just disallow first 4,000, right? Donation. So donation, you have to disallow. Earlier, this one, no adjustment is required for the auditing because audit anyway, it's related expenses. Without audit, they can't run tax fees. Then it's allowed, right? Right. So donation, what you have to do is you have to add back the plus column because accountants, they have already deducted. We have to add back again because as a tax people, we are not allowing these ones, donations, right? Because donations, they can't deduct, reduce the profit by saying that they made donation. They need to pay tax only pure profit, right? So according to the tax principle, right? But what I notice here is it's approved charity. Then you need to remember this one again. Put R here. Why? Why we put R? Why we need to remember this? Exactly. Exactly. We need to remember because qualifying payment. We need to take this one again, come back to here and do the qualifying payment adjustment. Qualifying payment adjustment. Then 1/5 of the taxable income or maximum we can claim how much? Exactly. 500,000. 500,000. Then whichever is lower, right? Whichever is lower. Whichever is lower, we can claim. 500,000, whichever is lower, we can claim. Then technically lower amount is by default 500,000. If you can remember, you can deduct because if it is a big amount like millions, then you can blindly apply 500% as qualifying payment, right? If it is millions, like if you take the accounting PBT is 730 million, right? Then these are with this adjustment, definitely you can blindly apply 500,000, but you can clearly show one principle. But I encourage you to put a bookmark in the open book reference as qualifying payment UP and put a small sticky note. Right, all good. So then foreign travel expenses 5 million incurred by MD marketing director to attend packing exhibition in Germany, which was essential for it's foreign travel, but it says essential. It's important to secure UK consulting contract. Then it is mainly connected with business. Without that, they can't run the business, right? So it is then fully allowed for business purpose. Yeah. Then fully allowed. Then if accountants, they have deducted already, we can't deduct again. Then we can say allowed, right? I will say here allowed, right? Right. Then Then repair and maintenance, 10 million, right? Repair and maintenance, 10 million. This includes 6 million incurred for major structural extension. Then this major structural extension. With that, they will increase their factory value, right? Because if they have major structural extension, they will increase their plant. Then the value, right? Factory roof to accommodate new machinery, right? Then with that they will expand their production, right? Written down value of the factory building at the end of the previous year was nil, 0. Then under this, right? Under this, what will happen? This is the major improvement, right? It's a repair and improvement. Under the improvement, this will fall under class 4. That is class 4 assets, right? Class 4. That is, if it is the written down value previous year is 0, then you can claim 12 years capital allowance. Capital allowance for 12 years, right? It's there in the act, right? If you go to this, definitely you need to bookmark this one, right? Sorry, class 4, right? Class 4, it's improvement in depreciable asset, right? %12 of the written down value if the previous written down value is 0, right? So if there is no, so then these classes, if you highlight, all right, sorry, and maybe you will have the separate schedule here, and then the class 1, class 2, likewise you need to remember these ones, what is mean by class 1, class 2, class 3, class 4, and there's a special adjustment that we are going to discuss right now, that's 12 years one. So this one and the capital allowance, you need to bookmark that one. So what is mean by class 1, class 2, likewise. Then the building structures we are going to discuss now, 12 years, because it's special adjustment that is not exactly here, it's a separate amendment came, right? So otherwise class 4 is 20, but if they, right, if the written down value is 0, we will go with the 12 years new amendment, right? So you need to remember these ones, but if you can't remember, put a sticky note and capital allowance schedule, right? So that is important. So this one, what we are going to do is, you need to apply 6 million. So 6 million divided by 12. So you can claim, sorry, capital allowance. First, what you have to do is 6 million. First, you have to do what? First, you have to add back how much? Because it's improvement, capital nature. Capital nature expenses, even though accountants, they charge into P&L, we have to add back. Then claim how much? Here, 6 million divided by 12, right? I would say class 4. It's not 20. If there is no written down value, then we need to go with the new amendment 12 years. Yes, exactly. right? Then you can claim here, right? 6,000 divided by 12, that is 500,000. 500, right? Deduction. No, bad debt write-off and because in the accounting, you need to check the what P&L charge. That is provision, it's charged to P&L. And then the write-off, they are not bringing that one into P&L, right? So if it's specifically in the exam, if you notice that it is charged to P&L that amount, then you can add back that one. So whatever the provisions they charge to P&L, right? Yeah, why 6,000 net? Because it's capital nature. It's a improvement, major improvement, that is we identified as capital nature as improvement. And improvements will fall under the new amendments under section 4. If there are any improvement, structural extension, you have to divide it by 12, not 20, right? If there is no written down value. Then P&L, they have charged altogether 10 million. Then we added back capital nature 6 and then claim 500, right? Hope it's clear. A bad debt also the same. Bad debt provisions, they charge to P&L. That is, we are adding back accountants. They have deducted. For tax purpose, we add back and claim the actual write-off based on the recovery action taken. Right. So, and then staff welfare. Staff welfare, 4 million incurred on standard employee healthcare insurance. So, staff welfare, are we going to do any adjustment for staff welfare? No, because it is allowed. No adjustments required. Allowed. No adjustments required. Right? Then when it's come to the next one is the another important thing. Hope you are aware this one as well. We'll quickly do. The finance cost 40 million comprises interest on long-term bank loan 32 and lease interest. Lease interest on delivery truck 8. Then this 40, 32 plus 8 become 40, right? So the total balance of these financial instrument at the end of the year was 400 million, right? So we don't care about this. It is also considered as finance as per the act, right? So for lease interest or borrowing loan interest, right? Loan interest fall under the finance cost. Then we need to consider those two when we are doing the finance cost adjustment. That is, in simply we call it as think capitalization adjustments. Oh no, sorry for the one question asking previously. All building 12 years? No, because buildings 20 as per that, right? Only if there are any improvement which are not having the written down value, right? Written down value, then you will get that, right? If you search class 4, you can see in the case of improvements, right? in the case of repair and improvement, and then in the case of improvement class 4, in all other cases, 12% of the written down value of the asset end of the previous year, right? With this is the amendment came with the April 1st, 2021 onward. Right? And coming back to again finance cost adjustment. Right. Here you notice that financial instrument, that means the loan amount, outstanding total balance of financial instrument at the end of the year. That is loan amount. Then you know that interest, finance cost, and the financial instrument. Financial instrument. Then the adjustment goes financial cost divided by financial instrument multiplied by what? How many times? Exactly. How many times? It's 4 times, right? 4 times into what? Right? Into 4 times. Then we don't have that information. We'll look at, keep it here. And what other things we have to consider? Okay. Then when it's come to note number 5, it says equity composition. Then the multiplied by equity, but equity they have given as at 31st March 2026 as follows. Stated capital 20, return earnings 40, and revaluation reserves how much? 30. Then are we going to take all these three or only stated capital and return earnings? Are we taking stated capital? Yes. Perfect. And then return earning, yes. But for this one, we are not taking revaluation reserves for thin capitalization. So only 60. 20 plus 40, that is 60. This is the. Then here, this once you solve this formula, that is finance cost is altogether 40, and that is 400. Then how much is the? Now we don't have 3 times. As per the new amendment, it's 4 times. Then allowable finance cost would be finance cost 240. Then how much is the, is that 240? No. How much? 40 divided by 400 multiplied by 240. Sorry. This one, yeah, you have to tell that the other answer, right? That's good. That is, this one comes, that's good. This one in total, you will get 240, right? That's good. This one, when you solve this one, you will get 240, right? 40 divided by 240 multiplied by, sorry, 40 divided by 400 multiplied by 240 would be 24. Perfect. Allowable finance cost 24. Then how much is the total? Total finance cost is 40. Then 40 minus allowable cost. Then we need to disallow how much? Disallowable finance costs. Finance cost 16. Right? Then according to ThinkCap, we need to disallow 16,000. right? 16,000. That is clear, no? Because we did it all together, right? That if you want me to put the formula here, right? It's in 1,000, 40,000 divided by 400 multiplied by 4 into, multiplied by, 4 into 60. Let's see how it's coming. 4 into 60,000. Yeah, this is the allowable cost. And then if you take total finance cost, 40,000 minus that, then you will get 16,000, right? Because I put this formula, if you get this Excel sheet, then you will see the formula how we have arrived to this figure, right? Finance cost. Then let's move to, then this one also taken or discuss, and standard tax depreciation capital allowance computed for the company's existing PPE year of assessment 25-26 amount 60,000. It's already given, capital allowance already given, it's easy for us. Then the capital allowance you can say directly 60. Because accounting depreciation and amortization we added 85 and we are claiming capital allowance less because accountant they can claim higher rates, right? That's why we are adding that one, and we claim as per the tax law rate given by the tax, as per the tax law, Income Tax Act, right? Then the next one, 1st October 2025, Ecotech invested 100 million a new roof solar power installation. Yeah, it depends sometime on student asking question, right? So it depends sometime you will get the cost of assets, right? Then you need to apply the rates and calculate the capital. They will say building cost is this much. You will get and the land also you can apply not applicable. Likewise, then they will get motor vehicle, computer with the fixed cost with the purchase year. Then you need to apply it. That's why you need to put the bookmark in the asset schedule, like capital allowance calculation schedule, right? In that, right? Here in the new roof solar power installation to power its factory, right? It's connecting to the factory, and this amount was capitalized in the balance sheet. No accounting depreciation or tax capital allowances for this one. Then no accounting depreciation, that's fine. Then we can claim capital allowance because it's anyway added to the book, right? So this one fall under the class 3 plant. So if you go to that one, so yeah, here you can bookmark this one because we really need that one when we are doing the calculations. So, right, which class is that, right? Which is class 3. Then the class 3 is if you say solar, right? The like plant, utility plant equipment. So this is coming under the part class 3. So rate would be, this is the fourth schedule, you need to bookmark that one, fourth schedule, capital allowances, then the 5%, sorry, 5 years in the sense, as a percentage, what is the percentage? Yes, perfect. Then class 3 asset 20% of, let's say, 100 million. Well, 20,000. Right. Then apart from that, during the year of assessment, company paid quarterly income tax installment 50,000, and valid withholding tax certificates are available for the 10% advance income tax. Sometime examiner might give the percentage, but remember it is 10% for your year of assessment, right? Then sometime you might not get this one 10%, right? Then you will just say the advance income tax on interest, FD. Then you have the gross interest here, then multiplied by 10%, right? Then you need to remember that one. Then this part will come at the end. Remind again, because this one credit part calculation, the last part, right? So apart from that, then we were doing the plus minus, and then we'll do how much is the plus side is, right? Then we are getting this much, but you won't get any marks for these totals, but you will get mark for the calculation of the assessable income from business, right? This is the amount you need, adjusted assessable income from the business. Then you will get 1 mark after total, but not the entire calculation 1 mark, because you got a lot of marks in between, right? Doing the calculation. Right. Yes, you are correct regarding the was advance income tax percentage. Previous year 5%, 25, 26 is 10%. Yeah. Right. Then what we need to do is investment income. Can you remember we remove the investment? So interest, then I will add that one here, because we remove interest. We need to add separately as the separate under the investment, because when we are going to calculate business, we remove that one, and then we need to take separately 20,000, because it's fall under the investment income. And because I know that some student ask what happened to why we removed disposal of gain on disposal of shares, because we remove from the business and then it is part of the investment income, right? Then that one we have to take it separately. Then we call it as total assessable income, right? We call it as total. Then if you want, you can take these two here and then total this way and get the total investment income in a way like to present well, right? Total investment income this much, and total assessable income would be sum of these two, right? Sum of these two. Right. Right. I'm not commenting those. So, and then qualifying payment. Then because once we calculate the assessable income, uh, assessable income, then what you need to do, you need to remember the format, right? So because if you really want, you can have like sample format in your open book, like not the full computation state, but you have the, because it's a sample short note, you can simply say this is the format, right? So then just for your reference, then you know what to do next. Once you calculate accessible income, then deduct qualifying payment, right? Donation to approved charity, because you can remember, even if you forgot, then when we go with the R item, right, we remember R, we put R here, okay, we have to come back that one, and this one, this R also we have taken already now. Then you can put this one we take, but again we have to do the advance income tax, right? I will come back again, right? So this one we have taken, but I have to come back again because we need to calculate the capital gain tax, and there's another part separately we need to address in this question. So apart from that, what else? Oh, okay, this one, donation to approved charity. Since it is approved charity given, then according to 1/5 of the taxable income of 500, then if you take accessible 1/5 of the accessible income, because taxable income anyway lower than this amount, then it's 155 million, because in thousand here. So then blindly even you can say, better to mention your logic, 1/5 of taxable income or 500,000, right? Then you can say lower of, then to show your knowledge. Then examiner, they can't lose your marks, so you have given the explanation, right? Then how much? That's 500,000. Sorry, that's, you have to minus with 1,000, that is this much, right? Right. Oh, good. Then after deducting that, then you will get taxable income. How much you are going to pay as tax. Sorry, uh, how much you need to consider for tax purpose. This is called taxable income. How much you need to consider for tax purpose, right? Then when you're going to calculate the taxable and tax liability, so you need to identify, because you can remember we put a R mark again. If you go back here, your total income belongs to exports and local both, right? Then because export liable to tax at the rate of 15, local sales liable to tax at the rate of 30. Then these two considered as business, right? Business. So first, what we will do is business only eligible for qualifying payment. You need to remember how much is the, you need to take how much is the business. So business total is, before investment, business total is this much, right? Then if you deduct qualifying from that, right? If you deduct from this qualifying payment, right? The exact taxable business income would be this amount, right? This amount. Because we don't take qualifying payment for interest. right? If you are doing business only, you can take the qualifying payment. That's why we need to consider, right? Consider only, very carefully you have to listen, then only the business. Then we deduct qualifying payment from the business. Then this amount is the taxable business income, right? Taxable business income. Then what you are going to do? Then this amount you need to apportion. Then how much is the turnover? Then you know turnover is, right? Turnover is altogether, I will put, I think we haven't put over above, right? Total turnover, if you go to section 2,800, that is in billions, right? So total turnover would be, I would use millions because it won't affect anyway, because just to apportion it. So total turnover would be this much. So then manufacturing would be how much? From total, this one divided by total, but manufacturing belong how much? For manufacturing, turnover is how much? Manufacturing 2,000. If you look at here, local sales, manufacturing 2,000. Right? 2,000. From this amount, we are going to calculate the 30% rate. Right? How much? Total from this total turnover, how much is the local sales? Right? 2,000. Is it clear to everyone? Put yes or no. Because that's why we apportion business, yeah, into this way. And then this one multiplied by 30%, because then we got that amount based on this calculation. And then again, total turnover is this much. And then what? This amount divided by total turnover multiplied by 800. Yeah. And then that amount into what is the rate? 15%. Yeah, very good. 190, 200. And then you are going to apply 15%. Then you calculated tax liability for manufacturing, local sales, and export service separately, right? In the exam, I encourage you to show the percentage, because here I just apply, you can see in the Excel what is the percentage, because it's anyway here. So I recommend you to show the calculation with the percentage, right? I'm not going to add another row because we have all the answers above as well. So here's rate is there anyway. So this one multiplied by percentage, right? Then here if you want, I can type it here, 175, 500, and here 190, 200. Then taxable investment income. Then how much is the taxable investment income? Then you can remember here we got taxable investment income is, right, 110, right? Taxable investment income is this amount, because earlier, as of now, we did this part, and then we need to consider taxable investment income. Under that, then what we are going to do is here in total taxable income, but if you take interest, then I will show it separately. Interest we'll take it here just to show the calculation how it looks like, right? Total investment is this much and the rate is 30%. Then the capital gain tax, earlier we had different rates, but now we all have fixed rate, right? The companies, not like individual, then they will get capital gain tax also. Then if you look at the capital gain tax note, then it says, I put R here again, then no tax have been paid on this transaction yet. Then we have to calculate. If they have paid, then we can claim the credit here, but we need to include in the calculation. Remember, we need to include in the calculation and take the credit. But I'm not taking the credit here because they haven't paid that tax. Yeah, this one is asking again to explain, right? But you can watch this one again in the video and post it and watch it again. So, right, then if I quickly explain it, then you had business as per the calculation, you got plus minus after that. This amount 666,200 is the, and then business can only deduct qualifying payment, not interest, right? Then take that amount and total turnover. How much is belongs to manufacturing? Total turnover. Then if you want, I can put it here like this, and then total turnover is how much? 2,800, and multiplied by 2,000, you will get this amount, right? And again, right? Then again, if I did this, do the same thing, 2,800 is the total turnover and multiplied by export turnover. Then you will get this amount. Then multiplied by 15%. This is the local sales liable at the rate of 30 and export sale liable at the rate of 15. All right. Then interest income liable at the rate of 30. Then the realization of investment asset tax at the rate of 30. Then altogether, total tax liability would be this amount, right? Total tax liability would be this amount, right? Then what you can do is, then you can remember I put R for interest, right? Right. Then interest, I need to take this amount multiplied by, if you can remember, I put again R here, 10% advance income tax, right? Advance income tax. Then you need to take interest. How much was the interest income? 20,000, right? Here also there, right? 20,000. Then advance income tax rate is 10, right? Advance income tax rate is 10. Then they can deduct minus 2,000, right? And then in the question, you can remember it says again 50,000 they paid as quarterly installment, right? Quarterly installment, 50,000. Then it's there anyway. Then at least in the question, if you run up with the calculation part, if you can't do this one at the end, just put the rates and then put these figures because it's anyway they are now in the question. Just you will get 1 mark each, even though final payable is incorrect, right? Then you will get final balance tax payable is this amount. I encourage if you have clarification issues, right? Watch the recording again because we are running out of time now here in Melbourne, 10:35, right? So We'll quickly jump on to the last part. These two are very straightforward. Right. All right. So this part is done. If you hope it is clear, I did the most explanations, right? And if you have any questions, you can watch it again and you can reach out through emails to Mr. Aruna Sri Lanka and we can clarify later if required to me or either way. So, and then B, right? Explain tax deductibility of 15 million expenditure under the board proposals in strict accordance, right, with the statutory definition of research and development expenses under the IRA. Then if you, because I encourage you to bookmark research and development expenses as well in the act. So it says clearly if they go with the research and development, right, that scientific research, right, then the word, if it is a scientific research, then you have the act itself because you can search it and highlight it, because I encourage you to use the soft copy and search things if really when we are doing the questions, and then you search it, and then manual act you just highlight, because manual act, if you are taking the initial act with the subsequent amendment, full picture might different, because original act they are having something else because subsequently it's changed, right? Therefore better to prefer online act if you have a printed version, if you can have it for study purpose, have it that one and highlight the changes, because sometime in the original act this is not there, right? Then the, because if you want me to show that one number of years in the original act, this 6 they added in 2021, only consolidated version it has, right? If you open this one, if you go to exam with the right, this act, then they have only 1 2 3 4 5, only class 5 only, but amendment subsequently they add another class, right? Likewise the colored, all the colored things, right? 6 means milking machine, so all this stuff they added subsequently. Therefore I encourage you to refer, because you can see all the amendments with the color, which amendment came with color, they have incorporated those, but not the last one. Last one is not applicable for your exam, therefore this is sufficient, then you can go through with that. And then you can select the whatever the relevant section. Then if you go to research and development, this hyperlink is there, then the section 15, and then click that one, and what is mean by agriculture startup, what is mean by research and development means you just bookmark. But sometime in the original act you don't have this colored thing because these came with the subsequently, then you need to take the shorted version or they go to the 2021 amendment, or otherwise you can use AI technology or whatever they summarize, and you can use your own short note, a small one, what has happened, right? Likewise you can do your best, whatever the best way you can refer, right? Right. Then when it's come to here, right, if it is research, scientific research, then if it is based in Sri Lanka, any institution, if they are doing that research, institution based in Colombo, that is Sri Lanka, in simply in this scenario they have given Colombo, right? Wherever in Sri Lanka, if they are doing, or in-house within the company or outside institution, but it should be in Sri Lanka, they can claim that research and development. If it is outside scientific research, so they can't claim this one, only they can claim any they are doing the research only for the if they are doing any research within Sri Lanka or in the company itself. But if they go with the business process improvement, like improving business products or processes, then that doesn't matter. They can go with the foreign country as well. But you need to carefully look at, if you get a question like research and development, you just carefully look at which is come under scientific, industrial, agriculture, something research. Then any institution in Sri Lanka, right? Then they can claim that deduction, no restriction. Business process improvement, they can go even beyond Sri Lanka. But in this case, it is both a scientific research, this one, scientific research. So therefore, they can claim only this first one. Then it's there anyway in the answer. First one, if they are doing within Sri Lanka, first proposal, because this managing director wanted to evaluate which proposal is the best for tax purpose. So they can go with the first proposal. That is the Sri Lanka. If they can do the research within Sri Lanka, that is help in a way that Act has designed that Sri Lankan company also getting benefited by having the research within the country. Then they will get some employment opportunities, all these stuff. So then if they are doing outside Sri Lanka, they don't get the qualification. They can't deduct for tax purpose. Right? Right. Then the last part of the question, part C of the question 8. So in relation to gain on disposal of shares calculated in part A is state. You need to specify the tax return, because if you have the gain on realization of investment asset, gain on from shares, right? You need to do which return? You need to submit a separate return. You need to file a return. What is that return? If you have disposal of shares, disposal of land, you need to submit a separate return, not like income tax return. But you need to consider for calculation purpose, you need to consider, because in capital gain also become a part and parcel of the income tax act, right? Capital gain, then if we take income tax, then it's comprised like advanced income tax, right? APIT, advanced personal income tax. Then this is again withholding tax, we call it as, right? And capital gain tax, different names. We call it as corporate income tax, right? Individual income tax. Likewise, income tax is the broader one under the Inland Revenue Act. But these part, individual income, they have separate return. Corporate income tax, they have separate return. Advanced income tax, separate return is there. Companies, they are required to file. Or banks, they need to submit that return. APIT, they have separate return. Capital gain, they have separate return. What is called? Can someone tell me? What is that return? Then VAT tax is a different law. Then value added tax. Under the value added tax, you have VAT return only. Earlier, there was a SWAT option as well. Then, if you have capital gain, you need to submit which return? No one there. If you have capital gain, sale of shares, sale of land, right? Which return we need to submit? these are all the returns, right? Here, if you want capital gain tax return format, this is capital gain tax return. Then if you go to Inland Revenue side, then the stamp duty there, value added tax, you can refer those, right? Then the social security contribution, that is separate one, separate law, right? Right. So capital gain tax return is required to file them by them. Then outline the statutory due dates, both filing this return and making the respective tax payment to the Inland Revenue Department, right? Then when they are required to submit, then we can say capital gain tax return is due, required to file, but they haven't filed that one, right? Then when and payment, they would have paid this one, the capital gain tax, we calculated 27 million. They would have paid this one long time when the transaction happened, right? So when it's come to answer, then you need to mention that for 1 mark capital gain tax, they are required to file capital gain tax return when there is a realization happen, right? So, and then actually when, then the return must be filed within 30 days after the end of the relevant calendar month which transaction is occurred. Then let's say transaction is occurred like 10th, let's say 10th June, sorry, I will take our period 10th Jan 2026. Then they are required to submit on or before 31st within 30 days after end of the relevant calendar month. Then 28 February, right? February. I will take round month. It's easy otherwise. Let's say your transaction happen like 15th November somewhere in 2025. Then they would have submit the not November month. They have 1 month on or before 30 days after end of the relevant calendar month. That means after November, that is 30th December 2025. Then capital gain tax payment must be remitted to Inland Revenue Department on or before the due date of for the filing return 30 days after end of the relevant calendar month, within 30 days. Then the same like this. No need to specify in the exam. If they ask with the due dates, they would have capacity to explain that one with the dates. Otherwise, you can bookmark these sections. Are there anyway I have mentioned? You can bookmark in the act. Right, we are now reaching to the end of the paper discussion. Do you have any other questions before we wind up? Hope it is clear. Was it clear the today's session? You can say yes or no at least to wind up. Yeah, happy to see your feedback. I wish you all the very best for your exam, and hopefully you will get through definitely. If there are any questions, you can reach out to me with social media, or you can reach out to the Mr. Aruna there. We can wind up the session. Mr. Aruna, are you there? Or just I will close this one.
Yes, I'm Mr. Kogila.
Ah, Mr. Aruna, okay.
Right.
Oh, good.
Thank you.